Litigants will be back here in for court, and they'll be looking for help. They'll be looking for someone to help them craft their own solution to the dilemmas that they have gotten themselves into, and figure out a way to fix their problems. And they're counting on you, volunteers, to make that happen. So we're very excited to have you back today. The mediation program as a whole has had its ups or downs. I just like everything in the court system for the last 2 years, I think we're just sort of using baling wire and duct tape and just trying to hold the thing together. And we did okay. We got out of it, and we don't have a huge backlog. We have some backlog of cases, mostly jury trials, hence all the jurors that we brought in. But we're just trying to get things back to where we were. And we had a director of our mediation program resign. She was seeking opportunities elsewhere and has started her own firm and her own practice and stuff. And we hope it's very lucrative for her. But meanwhile, that put us in a dilemma. We had nobody to run our program, and most importantly, manage this transition back to partially in person and figure out how to revamp the program. So we thought about it, tried to figure out what could we do to try to get the program up and running again. And there's really two components to it. There's the small claims mediation, which handles maybe 1,200 cases a year. A lot of cases are resolved through mediation in our program. And we knew that was going to come back. And then we had our family and dependency mediation, which also handles about 1,200 cases a year. And we knew that needed to come back too. So we had those two components, and we were trying to figure out what to do. And I said, I wonder if Dave Wilson will be interested in coming back. Dave ran the program for years for us, and really ran a great program back in the day. I think we resolved like 2,500 cases a year. We had about a 75% settlement rate, which is really good for our cases, and just Dave ran a great program for us. So we're really excited, and contacted him, and it took a little bit to lure him out of retirement. He was enjoying himself down in Apalachicola.
Yeah, to dig me up.
Yeah. Take him up, reanimate him, bring him out. But no, he jumped right in. Just a ball of energy. It makes me tired watching him. Because I'm getting close to retirement myself, but just watching him jump in with both feet, just get this thing going, just all different facets of our program. This is a perfect example, putting together this training and getting everyone back in for some refresher, brush up before we start in person next week. And all, so it's just really exciting that he was willing to do that for us for a short term. And of course, midterm, we're looking at hiring a new director. I think they've already interviewed and maybe selected a candidate. I guess we're just in negotiations now on who they select, and someone who's very well thought of in the mediation community. I'm surprised that we can make this work, hopefully. But we're very excited. Hey, how you doing?
Hey.
We're so glad to have you here.
Oh, thank you.
So anyway, David put together a star program of trainers and experts and people. We're very excited by that.
Sorry to interrupt everyone.
No. So just very, very excited to get together an all-star program. You're going to see a lot of familiar faces, Kimberly, Susan Marvin. You're going to see a lot of different people come back and teach you, work with you, and I'll learn with you. Just sort of everyone learning together, or again, reminding ourselves how these things work and what we need to know that's important. So we're very excited. You've probably already had breakfast, but if you do get hungry and need like a sugar rush to keep yourself going or something, we have donuts for you over here. At lunch, we'll be taking a break, and I believe Jimmy John's subs are being brought in for you, and chips and drinks and stuff. So we're excited about that, and just excited about just having you back and having people back. It's just nice addressing a room of people. I haven't done that in 2 years either. So it's just exciting seeing everyone here back in person and interested in what they want to do and stuff. So with that, I'll turn it over to Dave. You good?
Greetings. No.
That's
He
not a
lost
good
his
sign.
picture. He lost my picture.
It just went away now? You just hit a button, of some
I
sort.
just turned it off, turn it back on.
Reboot.
When it out, reboot.
Yeah. Was it showing what was on your screen?
Yes.
Maybe it has a timeout thing if it's not used for a few minutes or something.
Hi, folks.
Hey, I'm gonna get an IT person.
Guys, lots of old friends,
Yeah.
Nice to see you all. New friends, nice to meet you all, and I hope that we can work as well as we have in the past. This has been our core for, I don't know, I was here 8 years ago for 10 years, so most of it has been here since I started. So it's good to have you back and the new faces. I'm glad to see you. Welcome. And we hope that we can put together what I had before. I had a unit that settled 75 to 80% of their cases, that did 1,200 cases a year, easy. We had a really good technique and a good process. And one of the reasons that we had such a good crew is because of training. We trained every Tuesday morning. We're in crisis, Grant. It's gotta work. We train every Tuesday morning for an hour before we get started. It appears that the new calendars are gonna be at 9:30 instead of 9 o'clock. So we start at 8:30. You get, 50 minutes of CMEs every Tuesday, so there's never a problem with renewal of your mediation certification. For those of you who are expired, Kimberly, would you do me a huge favor and tell them what to do, because some of our folks have been expired for a while.
Okay. Well, good morning, everyone, and
Kim
sorry
Koch.
for the late arrival, and my apologies to the group. The great news, and really great news, is last fall, the Committee on ADR Rules and Policy changed what happened when you lapsed. If any of you had ever been in that position before, you had a very short time to renew, about a year window, but honestly, if you thought you were renewed and piped up 2 years later, it was hard to recapture. You'd have to go back to beginning again. So instead of that, anyone who has lapsed can renew their certification for up to 5 years. So that is times 5 what the requirement used to be. Now, there are some things you have to do. In addition to the 16 hours of continuing education that you would have had to report at the end of that 2 years, you're required to accumulate 2 additional years for every year you lapse. So that would be up to, if you lapse the whole 5 years, that would be an additional 10 hours. That would be the penalty. And regardless of the amount of time for county mediators, there is a lapsed fee, and that is $100. So you are out a little bit on the price tag, but the ability to renew, if I was talking to you pre-COVID, for those of you who have expired, the first thing I would start with is regrettably. And I'm no longer starting with those words. So, and while I would love to see you back at any of our trainings, it's 4 days and 20 hours. Well, now it's 24 hours of your time. County mediation training has increased in the number of hours. So, if you want to use me as a first doorstep to getting back into the process, email me. I'd be happy to then forward you either all of the information you need or send you to Dawn Burleson, who's our renewal manager. There is one other item. If you lapse for more than 2 years, you will have to go through background screening. Now, I'm not sure if Dave's unit can do that for you or if you would need to do that privately, but if any of you are coming up.
We can.
Okay, but I was gonna say, if any of you are coming up on 2 years and wanna save yourselves a little bit of time, postmarking your application before the 2 years would provide a benefit for you. Because even though Dave is saying he can do it for you, it's still something you would be required to do. And if any of you need to know where you are in that lapse timeline, I can confirm that very easily.
Kimberly, if they're lapsed, can they accrue CMEs while they're lapsed? So they can, when they renew, they can be certified?
Well, technically, yes, or we would have no way of instituting the penalty. It's not a penalty, it's just really keeping you current. And 2 hours is probably less than you would do in a year anyway in terms of your CME requirements. So yes, doing them during that lapse period will count, because when you reapply, let's say you're lapsed for 2 years, we would be looking for 20 credits from you. So upon application, we would have to have that information to move
So
forward.
these 8 would count?
Yes.
Kimberly, but you said something about renew for 5 years?
If you lapse,
Okay,
you have
haven't
the
lapsed.
ability to renew for up to 5 years lapse.
Okay.
So that's a pretty good, that's 2 renewal periods, and the committee thought that in 2 renewal periods, you hadn't figured out that you're no longer on our list, that courtesies would end,
But
so
you still have to renew every 2 years.
we still have to renew every 2 years, yes.
And you will get enough CMEs if you come here to
Oh,
read.
yeah.
Absolutely.
We do like 16 a year and 2 trainings.
And the DRC also
Yeah, I
has
have it.
accumulated and put out on our website, and I'd be happy to send it to any of you, a free CME listing, because one of the things that COVID has produced is a lot of online training, not necessarily all done by the DRC, but we have also been doing our own 1-hour ethics. And if you missed them when they were live in person, they're on there. We have about 15 or 16 programs that have interpersonal violence, education, cultural diversity, and then about 20 hours of just various topics that you might like and take advantage of.
And for your information, I am a stickler on ethics. I'm an ethics freak. So you're gonna get pounded with ethics.
Well, you are today.
Well, you are today. You sure are.
Can you comment on the conference this year? Did anything change with
Do
that?
you want me to do that now?
Do you mind, Susan?
What?
Do you mind if we spend a few more minutes talking about the conference?
No, go ahead.
All right, and hey, Susan, the first thing I will tell you is that Susan is presenting at conference. So, and she's presenting on confidentiality. So if you do go, please stop by and say hello to Susan. So the conference is in person this year. We've had virtual platforms for the last 2 years. We're going to be at the Rosen Center on August 11th through the 13th. Educational events are largely on the 12th. Thursday is, we have a pre-conference. We are giving a discount of $50 for the county mediators off the early bird price, or actually your early bird price stays regardless of when you register. So for the volunteers, and Dave and Grant, that information will probably go out to the circuits this week in written form. So the price has gone up though. We had stayed steady at $195, and it's going to be a $300 registration fee. So for the volunteer mediators, I think it's at $249. So
You're back at the Rosen?
we are back at the Rosen Center, yes. For those of you who've been there before, it's across from the convention center, and sometimes we see lively events going on.
So did you schedule it when the tattoo conference is there?
You know, believe it or not, let me do a shout out to my son. My youngest son is an artist working at Capital City Tattoo. So see Cody if you need any artwork done.
Show us where, show us how good it is.
I know you got one.
But anyway, Orlando is always a lively place. The Rosen Center allows a lot of walkability to restaurants and other venues. In addition to the hotel's done some renovations and expansions, added some new restaurants. So we're going to be excited to be back. I also want to tell you that we heard a lot of wonderful things about our virtual platform, and the ink is not dry on the signatures or the plans, but we really hope to maybe alternate between virtual platforms and in person, so that those people who prefer either one or perhaps can't travel, or it is an expense to travel to Orlando and stay in a hotel and pay a registration fee, and we realize that. So I think next year we might go back to our virtual, and then every other year. That's our goal, because we did, again, hear so many positive comments, and we don't want to leave out a population of our mediators for any reason.
On the renewal coming up, mine comes up in a couple of weeks. Do all the CMEs from both of the conferences of 20 and 21 count towards the renewal?
Yes.
And
2 years, right?
Yes.
And if you did, like myself, I did in 2020, I did all of the classes that were recommended. and then went back there and did a second round, and then went back and did a third round, so
Because you
I,
listen to the tapes, or the recordings, I'm
Yes,
sorry,
and I
tapes is
dated
kind of dating
everything,
me.
so that's over and over, I must have went to 20 classes.
You probably got enough CME. Now, I don't know about the component parts, but you definitely sound like you earned enough CME. And that's one of the pluses of the virtual platform. We record all of our workshops, and you can, for 2 months, go back and listen to or take new courses. That's not a component of our live conference, so that will be a part that's unfortunately part of just the virtual offering.
And you suspended the requirement of 50% live.
We did. So if you wanted to or had to, for any reason, take your CME in a non-live format, and that means you're not really with a group of people or discussing things individually with, then you can do them all. You could, for example, just one more second, I failed to mention that one of the changes allows up to 8 hours of CME for mentoring. And I know that you do a lot of that in your circuit, whether it's county and family. So for example, Dave, you do, 8 hours of mediation on one day. So let's say that same person observes you all day long, half of their CME credits are already taken, and those mentoring a new applicant or a new mediator.
You will have the opportunity to do that.
Right. So every hour counts, every 50 minutes of mediation time is an hour of CME. So they recognize the value of mentorship, and the limit used to be 4 hours. Now it's up to 8 hours.
So, and you're gonna get almost half of them back.
Yes, yes.
Any other questions? Thank you, Kimberly.
You're welcome.
Blocking you on the screen.
Oh, all right. I will. No, you're just can't go
this way.
How about if I come this way?
Yes, sir.
Okay, wow. Susan Marvin, ladies and gentlemen. Susan. Freeze. I just got grievances, yes? Can we turn this, oh, wait a minute.
My sound up, would that help?
I don't know.
Is that any louder?
No.
Well,
So, all right, while you're starting, I'm gonna run down and get your other car.
But we can go ahead if she wants to.
You go ahead, Susan, if you want, maybe just talk as loud as you can.
Just yell.
If you're talking grievances, just shout at us.
Does everyone have a paper copy of the rules standing?
You know what? I do. I have them, Susan, but I haven't passed them out. Would that be helpful?
That would be great.
Okay. No, Dave emailed you all the Mediator Almanac, so that was part of my presentation, and I let the other trainers know, so they didn't have to make duplicate copies.
Has it changed since 2018?
It has. The latest date is 2021. Then I'm gonna cut here and ask you to get them out. No, I think I got it. But thank you, Larry. Okay, I'll be right back.
Oh, and I'm gonna test out my screen share while we're in this preliminary mode. Let's see if he gave me his order. No?
Well, I like training with Susan, so I kind of feel like these are the good old days. So thank you, Susan.
Susan, I'm gonna try to make you a co-head so you can do the screen share.
Oh, I'm sorry.
That's okay, thank you.
Am I like a big head on a large screen?
Yep.
Yes.
You're a big head.
I'm gonna put these over on the corner. My extra copies.
Okay.
Okay, you should have co-head's authority now.
Okay, is that Grant?
Yes, I know, it's just the corner of my head.
Oh, yeah, thank you. Great.
Love all these Zoom experts. I've never used it in my life.
So can you hear me now?
Yes. Enough, go ahead.
A little bit behind.
Speak.
Can you hear me now?
Not yet, not yet. Keep talking. Sing.
Keep talking.
Oh, I heard something.
Yeah, that's something. Make sure I have volume up.
Try now.
Hello?
Okay, it came up, I thought.
That's as good as it's gonna get, sorry.
It's coming out of there?
I don't know.
I don't think so.
It's got blue lights, red lights. It's like on a.
Make sure the back, switch on the back is not set to Bluetooth, because you're plugged directly in.
What is that?
Yeah.
I think it's just searching. I can look that.
It's the Bluetooth symbol.
Well, I thought I got it all right.
Well, I can hear you really well.
Well, good, that's because I'm screaming in the microphone.
Yeah, network. There you go.
I'm wondering, is it an add or it's another button up top?
Susan, go.
If you're plugged in, does that interfere with the Bluetooth?
I don't know.
That's pretty cool background.
And I'm not getting.
Yeah, maybe unplug it.
Yeah, I think you
I'm
got.
trying to do Bluetooth.
Right, exactly. There you go. Right, exactly. You'll have it like that.
Yes.
You see that button that says Bluetooth and other devices? I'm just wondering.
Okay, you want me to go outside, see if I can find someone 13 years old?
Make it 10. Let's see how it changed.
All right.
It's on. All right, go ahead. I'm getting out of your way.
Start the mic.
Mike, right here.
They didn't have a good class, so we'll try to fix it. Well, it's first break.
Okay. Yes.
So can you kind of hear me?
Well, yes, we can kind of hear you.
We can hear you, Sue, go ahead.
We'll be
Let's get
quiet.
this fixed, because they can't really hear it.
Kimberly
She's
Davis,
on
I'm
Zoom.
looking for rule 10.200.
All right, let's open up our almanac, everyone. Susan would like us to look at rule 10.200, and she picked one of my favorite rules that begin the process, and we would be on page past 15. '25, thank you, Tina. 25, so rule 200, page 25. I'm sure Susan's going to tell you that this rule really sets the stage for how the rules apply to us and what some of our basic charges are. So if you look at the third sentence, it starts with, these rules are intended to both guide mediators in the performance of their services and instill public confidence in the mediation process. The public's use, understanding, and satisfaction can only be achieved if mediators embrace the highest ethical principles. And then my favorite sentence is the last sentence of this paragraph. And all of the rules, if you only remembered one thing, this is my favorite sentence. Whether the parties involved in the process choose to resolve their dispute is secondary in importance to whether the mediator conducts the mediation in accordance with these ethical standards. So I can tell you over 25 years of working at the Dispute Resolution Center, Most of the grievances that are filed against mediators would fit under the larger umbrella that they have placed something over the ethical platform by which you should mediate. That might be trying to settle the case. Maybe they thought, this case should really settle, applying a little bit of pressure, doing something that the rules absolutely and clearly anticipate otherwise. And fortunately, and I know that Susan will tell you this, I don't want to steal all of her thunder, but there is a very small percentage of grievances that are filed with the Dispute Resolution Center. If you think of just even the court-ordered mediation that goes on, let alone the mediation that goes on in private pre-suit cases with agencies, with religious communities, it's like 0.0001%. It is a very, very small percentage. So we do know that our mediators, for the most part, act ethically. We also do know that it's people like Dave who are probably going to be the frontline persons who receive, just say, a complaint about anything going on in the program. Usually the DRC, I would say, is the last step, or perhaps they're not in a court-ordered program and someone like Dave is not available to the litigants. But we know that usually that the ADR directors are able to resolve a lot of complaints, which could include the room was too small. We all probably would agree that the rooms on this side of the hallway are all too small, but whether or not that would be a feasible grievance against a mediator, at the state level was, I would believe, questionable. But Dave would probably be the persons who those litigants found to express their displeasure. I've heard if you're in those rooms longer than an hour, the oxygen mask that's typically on an airplane will drop and you can continue your mediations. But personally, I think it's about 45 minutes. I start to feel like a fish out of water.
In the 10 years I was here, I had one complaint to me, and it was absurd.
Yes.
So, there you go.
Are we still working?
She's good.
She's.
Can you hear me?
Oh, well, we can hear you. Yay. All right, then I'll sit down.
Great. Okay, great. Thanks, Kimberly, for
You're-
taking us.
You're welcome.
And in fact, she pretty much said exactly what I would have said. Good morning. And if I look like I'm at a hotel, I'm on vacation, so I basically am at a hotel. Welcome from my Alaska family, my New York family, my 97-year-old mother, my 2-year-old grandson. I'm enjoying all their company, and you. I see some familiar faces, so good to see you again. So today I'm going to talk to you about the rules for certified and court-appointed mediators and common mediator ethics violations. And I was thinking about this and I thought, you don't want to go talk to people about a bunch of do not do this, do not do this. So I'm trying to come up with some different, you might want to avoid doing something so that we can frame it in a positive light. And to begin, you know that the rules are divided into 3 sections. Thanks so much for bringing the paper copies, Kimberly. And the first section, Kimberly's already, I heard her talking to you about renewals. So we know that the first section is mediator qualifications. The second section is the standards for professional conduct. And that's where we started with Rule 10.200. And then the third section is the mediator certification applications and discipline. So we're going to focus on part 2, and then, if you have any questions about the discipline process, I could certainly answer those, but I didn't know if you wanted to walk through all that. Because hopefully none of you will ever have to go through that. And that's what we're talking about, ethics. And indeed, David was my mentor when I started mediating, and David always said, it's better to do what the rules say than take any risk of having a complaint filed. And So we all want to follow Rule 10.200. Kimberly was very nice and read it to you. I might ask some people to read out loud to keep everybody awake, since you might be inspired to nap by the bed in back of me. That's how I'm going to have audience participation. But indeed, she focused on exactly what are some of my favorite sentences in the rules. I guess when you read the rules a lot, you end up with favorite sentences. But definitely the public's use, understanding, and satisfaction of mediation can only be achieved if mediators embrace the highest ethical principles. And what's more important, that last sentence says, is having people have confidence in mediation. That resolving their dispute is really, that's a great outcome. We encourage you to do everything you can to assist them to resolve their dispute. But the main thing is that you behave ethically. And I'm sure that makes sense to all of you. So we're going to review a few basics. And I am starting with some real basics that you all know and you practice. I just thought we could talk a little bit about self-awareness for the mediator. I'll talk this much about it. When you are a mediator and you wake up on that day, you want to be well rested and you want to prepare for your mediation by doing whatever you do to have inner peace on the day of your mediation, because you bring peace to the mediation room and you bring conflict resolution and all the professionalism that we just talked about in Rule 10.200. And this goes to our own demeanor. In a minute, we're going to talk about some complaints involving mediator demeanor, and that's why I'm talking to you about bringing peace, inner peace to the room. So be aware of what your attitude is, how you're feeling that day, and do whatever you need to do to move it to a positive framework. Maybe you meditate, maybe you pray, maybe you listen to music, maybe you go for a jog or some exercise, but get to that peaceful frame of mind, and then you can bring that to the room and the parties. And then you want to be other aware. You want to be aware of the parties and the level of conflict they have. So, sometimes I wonder how observant I've been in my life when things happen. But this is a good time to be observant. Read their body language. Read the temperature of the room. Is it a high conflict or a low conflict? Maybe you can tell that people are angry by what they say right off the bat and how they look and what their body posture is, or maybe they brought a whole bunch of peace to the room, which is terrific. So just be aware of them too. And the other thing I don't think we can be reminded of too many times is they are a deer in the headlights when they get to court, right? Dave, do we have family and small claims and county mediators?
We do. We do.
Yeah. So especially you that do small claims and county, particularly small claims, when they come into that pre-trial conference, they never have been to a courtroom before, and they may not have been to a mediation before, or even observed, or been a party. They may never have been a party to a lawsuit. Of course, you're going to have repeat players, but the parties, at least one often, has never been involved in any of this. So you can, if you kind of put yourself in their shoes, it's all very strange. They don't understand the language maybe, and they might be a little nervous and anxious and scared about what's going to happen. And to include dependency and family mediators, of course, you don't see them at pre-trial, but those are important cases too, and people are just as anxious, maybe scared and uncertain of what's going to happen. From my observation, if they have attorneys, particularly in the family law and dependency, they might have, dependency, they would have attorneys, and family law they might. Sometimes the attorneys don't prepare them all that well. Maybe you've noticed that too. I know you've done most of you have done this before. So keep in mind that they are deer in the headlights. And you've done it before, but be sensitive to that they don't know everything you know, and just treat them with respect and professionalism and courtesy, because this may be the only experience they ever have in court. We hope people don't need to go to court for mediation, although it's a wonderful thing. So we want to leave them with a great experience, a great ethical experience. So that all goes to demeanor. And my one other little caution there, it's to lighten the mood, you might try to use some humor. Humor is a great thing. I use it all the time. It doesn't always go well. I use it with my 97-year-old mom. She doesn't always appreciate it. Be careful, because you want it to be something that doesn't offend them. Self-deprecating humor, I think, is a great thing because it won't offend them, hopefully. So humor is good, but be careful. And all of that being said, as the basics, I'm going to start in on the common mediator ethics violations that could lead to a complaint, and that complaint could possibly lead to sanctions, which you all want to avoid. Nobody wants to spend their time being briefed and responding to it, right? I know I don't. So I love David's advice that, just behave ethically, and you don't have to have any concern about that. Somebody can always file a complaint, but you'll have a great defense if you did everything ethically. And we'll start with the demeanor category. And where I get this analysis is I went to the DRC website, flcourts.org. I went to the discipline page, and the complaint cases are divided into 2 categories. Many of you may have looked at those. Kimberly said, just like I will say, that there aren't that many complaints given the number of mediators. It's less than 1%. Just like the Florida bar has less than 1% of grievances against attorneys, so it is with mediators. Hallelujah. So it's not a big group, and there aren't that many complaints on the website, but that's where I'm getting my information, as well as my memory and some hypotheticals we made over the years I was at the DRC for trading purposes. And we usually made those hypotheticals just from the complaints themselves, and took all the interesting things and put them together. So demeanor is rule, you can tell me what rule that is.
10.350.
Yes, you are right, 10.350. So
Page 31.
Yeah, let's, I see, is that Mr. Parkman? Do I see Mr. Parkman?
Yes, you do.
Hey, since I recognize you, could you read Rule 10.350 up and out? It's very short.
We're on page 31, you say?
Yes,
Rule 10.360 or
350.
350. A mediator shall be patient, dignified, and courteous during the mediation process.
All right, thank you.
Well done.
And that's one we could memorize. It's only one sentence. And you all do it anyway, right? You wouldn't be attracted to this profession, I don't think, unless you were those kind of people. So just put up patience, be dignified and professional, and courteous. Everybody enjoys courtesy, right? We all like to be treated with respect and courtesy. So the complaints that involved this rule and mediator demeanor, if you look at the disciplinary page on the DRC website, I'm going to summarize some of them Mediators raising their voices in an intimidating manner. That's not a good idea. I think there were several complaints, maybe they didn't make it all the way to the sanction level, but raising your voice in an intimidating manner is not a good idea. And I think that happens when we as mediators, if we do this, or if we do it in our life, in our home, or with our friends, when we get impatient and we're feeling frustrated. So what could we do if we're feeling frustrated in a mediation? Could we take a what? Break?
Caucus.
Yeah, a caucus. You can have a mediator caucus. I don't know if you ever thought of that, but
For you to sell?
everybody in the room.
They both think
Okay.
you're with the other party, and then you're calling somebody to either get an answer or calm them down or something like that. They don't know where you are. They both think you're with the other party.
Go out in the hallway and take a couple of deep breaths.
Or scream at the top of your lungs. Do that outside.
Yeah, go far away if you're going to scream. But so if you need a break and you're feeling frustrated, it's better to take a break than take it out on the parties, right? Or the attorneys if you happen to have any.
Oh, no, that's okay.
So mediators raising their voices in an intimidating manner, making a sarcastic comment about what the party might get the judge to believe. All right, if you have some feel for the judge, you have some experience and what the judge, he or she might do in these circumstances, you don't want to say that to the parties. If they have attorneys, the attorneys can do that. If they don't have attorneys, then you can form questions and ask them, do you have any idea what the judge might do? Put it in some friendly, professional way. Kimberly's really good at asking good questions. But don't suggest what the judge might do. You could say, if it's small claims, you can say, do you have any feel for what the judge might do since you've heard he or she speak in the opening?
See if you can get that from the lawyer. And make sure you know the answer before you ask the question, because sometimes it'll undermine you if the lawyer gives the wrong answer.
But anyway, you don't need to be telling the judge what you think the judge is going to do. Some complaints involved making improper references to the physical. There's a particular complaint case on the website. Improper references to the physical possessions and attributes of a female party. This was small claims. Well, no, I think that was a family law case. Asking, although ask a party obtained, this is the same complaint. Making improper references to the physical possessions and attributes of a female party, as in asking how she obtained her engagement and wedding rings. Apparently they were impressive. Maybe the mediators thought they were making small talk, but again, be careful what kind of small talk you make. How did she obtain her engagement and wedding rings, and whether her watch was a Rolex, and stating that the party really was a beautiful woman, and I hope your husband appreciates you.
Holy toad. So I was laughing. They get so absurd sometimes.
Yeah, well, and maybe the mediator thought they were being complimentary with all of this, but you gotta put yourself, the person complained. So apparently it was not well received. They did not perceive this as a compliment.
And think of the other side, what they're thinking about you.
Well, yeah, unless it was in caucus, yeah, those are really strange things to say if everybody's in the same room. I hope you're getting a feel for your intentions may be good, but people have levels of appropriateness, and these kind of comments would not fall in that category.
So putting a revolver on the table when they walk in the door would probably be frowned upon, is that correct?
What did you say, Dave?
Putting a revolver on the table when they walk in the door is probably not the way to go, right?
Yeah. Right. Good work, you.
That's my, yeah.
Definitely a domestic violence or interpersonal violence issue there. Okay, so I think you got a feel for demeanor. The next category that was common on the website cases are complaints involving mediators violating parties' right to self-determination. We all know that the core principles of mediation are stated in Rule 10.230, and those are, it's kind of a summary rule. I don't know what page it's on, but 10.230. Whoever gets there first.
26.
There you go, Larry.
Read
it.
Larry?
Yeah.
Can you read those to me?
Okay, the role of the mediator is to reduce obstacles to communication, assist in the identification of issues and exploration of alternatives, and otherwise facilitate voluntary agreements resolving the dispute. The ultimate decision-making authority, however, rests solely with the parties.
Yes. So that's got some great core principles, right? If we're talking, we're about to talk about self-determination and coercion, and nowhere in that rule that Larry just read does it say engage in coercion. No, it says reduce obstacles. I love these words too. Reduce obstacles to communication. Assist in the identification of explore alternatives. Okay, so the decision-making authority is with the parties. We always have to remember that. And so if we go to Rule 10.30, self-determination, it gets a little more specific in A and B. Do I see Karen there?
Yes, you do.
Karen, could you read A and B of 10.310?
Decision making. Decisions made during a mediation are to be made by the parties. A mediator shall not make substantive decisions for any party. A mediator is responsible for assisting the parties in reaching informed and voluntary decisions while protecting their rights of self-determination. B, coercion prohibited. A mediator shall not coerce or improperly influence any party to make a decision or unwillingly participate in a mediation.
Thank you.
You're welcome.
Yes, I'm not having to read C just because that's a good one too, but the complaints I think involved A and B, and those were, I think the majority of the complaints that are on the website may fall under these rules. Oh, 10.310 and 10.370. Whoever gets to 370 first, did you read that one? That's the coercion rule. Anybody found 370 yet?
Page 31.
Providing information consistent with standards of impartiality and preserving party self-determination. A mediator may provide information that the mediator is qualified by training or experience to provide.
Okay. That part is even a little tricky, isn't it? Consistent with standards, it's got to be impartial and it's got to preserve self-determination if you're going to give any information. That first clause definitely affects the second clause.
Or advice. Or advice.
Yeah.
And we'll talk about that in my presentation. I got a whole deal on that.
Okay. So it's pretty narrow. It's got to be impartial and preserve party self-determination if you're going to give any information. And you'd have to kind of put yourself in the people's shoes. If they heard you giving this information to the other side, would they think you were being impartial and preserving everybody's self-determination?
Excuse Susan. You know,
Yes.
that is a real tricky one. When you
It
talk
is.
about the experience that someone is providing, because that experience obviously will go to whatever's happening in the room, and that experience will likely be on one side of the fence. So
Right,
it's just real tricky because you want to provide your experience, but it's usually gonna be beneficial to one and not the other.
yes.
That's
No,
true.
And usually you do it in caucus.
Okay, that might be the difference, but
But that's even worse.
So-
you say that's
so
even
you know
worse?
what? You know what you might wanna do with a difficult situation like that, personally? I would just not do it.
Don't do it.
If you can avoid providing information, then take that route, because it usually is gonna benefit one party and not the other.
Yes, okay.
It's just a hard standard. And then, you know, I'm not gonna read all of B, but it's about mentioning to the parties that they are entitled to independent legal advice if they feel like they need it. And then C is.
But be careful about that, because you're on the verge of giving advice to get advice.
Yeah, that's best in your opening statement.
Yeah. And that's the best place to do it, nobody stays
exactly.
then it's neutral.
That's when I do it.
Yeah.
Yes. And then C makes it even more difficult. You shall not offer a personal or professional opinion intended to coerce the parties. Of course, that seems like we coerce them, unduly influence them, okay? Decide the dispute or direct a resolution of any issue. Okay, that's getting a little tougher. Consistent with standards of impartiality. Again, here's the sieve that this has to go through. It has to be consistent with standards of impartiality and preserving that party's self-determination. Let's see. However, you may point out possible outcomes of the case.
Exactly.
Discuss the merits of a claim or defense. Probably you want to do that mostly by asking good questions. And get them to do some self-analysis, rather than you doing much there. Try to get them thinking. A mediator shall not offer a personal or professional opinion, as, remember I said, don't be telling the parties how the court's gonna rule. Well, here's the sentence about that in this rule. A mediator shall not offer a personal or professional opinion as to how the court in which the case has been filed will resolve the dispute. So, you know, that definitely is coercion if you're telling them how the court's gonna rule.
Susan?
If the attorney, that's exactly what the attorney is for. And if they don't have an attorney, you know, you feel badly for them that they don't have an attorney, but that doesn't mean that we can act like their attorney.
Susan, I have a question. It's clear that what the mediator should not do in this case, and you've just clarified that. But I've been in the mediation room when an attorney does exactly that.
Oh, that's
To the other,
That's the better
to the other party.
Now, what is our appropriate response? Do we contradict the attorney? Do we intervene? Or we just keep our mouths shut?
Yes. I will give you the best example of that in my presentation, because it happened. Well, let me do it now.
Okay.
Yeah, feel free.
My feeling is if it's unconscionable, you can't let it happen. You gotta terminate the mediation. And the way that it happened is, it was a family case. The lawyer for the wife came in and said, we want 10 years back child support. Well, you can get 2 under the statute, okay? So I said, okay, counsel for the father, do you have anything to say about that? He said, no. And I said, now I'm pushing my luck here. I said, are you sure there's nothing in the statute to cover that? I mean, I gave him an out. He said, no. I let it slide. Now, was it unconscionable? Boy, yeah. If she was pro se, it was unconscionable. But she had a lawyer. And the lawyer is her remedy. So when he screws up, I am not going to contradict him. That's his lawyer. Don't ever get between a client and lawyer, ever. you'll get in trouble then. So that's about as far as you can go.
Well, this case I have in mind, the attorney was for the plaintiff. And he said to the defendant, ma'am, if you were my mother, this is what I would do. And I've been in this courtroom, he said, I know this judge. In other words, he abrogated everything we're talking about.
Yeah.
He's not a mediator.
He's not a
No,
mediator.
no, what I'm saying-
You're
I'm saying I am the mediator, and I'm sitting there listening to this guy.
you have a right to independent legal counsel. That's your limit. That's what you tell them. If you hear something that is so bad that it shocks your conscience, either terminate the mediation or tell them you have a right to independent legal counsel. Right, Susan?
Yeah, I would do that. And do you think it'd be pushing it if the mediator said, that's the attorney's opinion, and you are entitled to form your own opinion?
I sure wouldn't go any further than that. That's on the line.
You know, I had a family mediation that falls into that category. It was online, and as we were going back and forth between the attorneys and the clients, I hit the button, and the client of one of the attorneys came on, and I said, just a second, I'll get your attorney on now. And she asked me a question, which is yes or no, and I gave a yes or no answer. And then the attorney came on, and he said, and it came up, and he said, did you speak to my client?
Wow.
And bang, it was over. It was over.
Wow.
That was the end of it.
The answer to that question is when they have an attorney, don't talk
Don't
to
ever
the
say
client.
anything to the
Do you
client.
think you were
So
set
that
up?
the attorney is online. I have no idea, but it was embarrassing. It was embarrassing.
Good point.
Well, these are all good issues you're raising, and I trust David, so I'm sure he can continue that conversation with you. Let me tell you, under this category, what complaints were that the DRC did have the mediator qualifications and disciplinary board review. Some of the complaints involved, well, in one of them, the mediator made threats to a mother. This would have been a family case. Made threats to a mother that unless she signed the agreement, she might never see her child again.
Oh, man.
That's definitely expressing an opinion, and it's really basically saying what the mediator thinks the court is going to do. And it sounds like, let's see, if we look back at 370, I think, it definitely violates impartiality, preserving party self-determination. It's intended, it seems like it's intended to coerce or unduly influence the party or decide a dispute or direct the resolution of that issue. Definitely seems like that.
And it's also pointing out possible outcomes of the case,
Yes.
so that's.
Well, you can point out possible outcomes of a case and discuss the merits of a claim of defense, but that would be without expressing your opinion. So it's, you don't want to be saying to someone, they might never see their child again. And that's a direct quote that was in the complaint.
Did you shoot that mediator or just decertify it?
Yeah, right.
I don't remember what they did to that mediator, but it's on the website. Another mediator in a family case threatened the wife with the possibility that the husband would file a motion to keep the children away from her, imprison her for a violation of a temporary restraining order, and cause her immigration status to be revoked. And I'm telling you the clear, bright line violations. Those to me are very obviously intended to coerce, decide an issue, unduly influence. They're not intended to have a discussion where the party can do some thinking and some analysis and come up with some creative problem solving. The mediators, remember that rule? Reduce obstacles to communication, promote problem solving. Well, these kind of statements do not reach those goals. So, and then the third one instead of advising a pro se parties of their right to seek independent counsel, the mediator told the landlord to settle and do whatever it took to get rid of the tenant. So, that's, again, expressing an opinion. Avoid those kind of statements. If I didn't bring mine with me, but I know that Kimberly regularly trains on the Dick's drop dead questions, and the Dick's drop dead questions handout has some great questions to ask. So, if you're thinking of making some kind of statement that expresses your opinion, stop and think of questions that you could use to get the parties thinking.
There's a Meac opinion saying you can't give advice with a question.
Yeah, true. Yeah, don't make it an advice question. Just
Like, do you really think the judge is gonna rule that way?
yeah,
Probably a little shaky.
you've got to ask open-ended questions. Right?
What happens when the attorney does all the things she's talking about that we shouldn't do and we won't, but the other side, the opponent's attorney is doing it? Tell him he can't do that.
Just caucus them.
Yeah.
Put them in caucus and don't let them do it.
And
That's how
because
you,
he's
that's
not
how you
talking to
diffuse
them.
stuff like that. Caucus the people.
Right, you can't control someone else's behavior. So that's why you would do a caucus.
Okay.
If people are misbehaving in a way that does not promote a balanced process and safeguard the basic tenets of mediation, caucus is a great tool for that. And just calmly say, I think we need to separate now. Mr. Jones, would you come with me to this other room? That is the way to do it. Okay, and the next category is conflicts of interest and failure to act with impartiality. And the rules for those, I guess unless if somebody wants to read Rule 10.330, that's the impartiality rule. That's an important foundation of mediation. It's got, why don't we just do A and B, whoever gets to that one. I saw John Catone. John, you want to read that one?
Which one are we doing? 330?
Yeah.
Generally,
A and B.
the mediator shall maintain impartiality throughout the mediation process. Impartiality means freedom from favoritism or bias in word, action, or appearance, and includes a commitment to assist all parties as opposed to any one individual.
Specific emphasis on appearance, because that's what's gonna get you. People will say, well, the mediator said, and you never said it. So the appearance is important.
Yeah, it's what would appear to them in their shoes. And B is just that you need to withdraw if you find that you're becoming impartial.
And if you have a conflict of interest, I worked with the Department of Children and Families for 2 years. That's an apparent conflict of interest when you're doing a dependency case. Disclose it and on opening statement, or as soon as it happens, disclose it and let them make the decision. There's sometimes you can't make this decision, and Susan will tell you about that. But at that moment, you gotta make a decision whether you're gonna go forward or not.
Right.
Sorry,
And
Susan.
then, oh no, you're fine. I'm gonna give you this much of brain information and how it affects people. There's some really good talks. One of my favorite is Doug Knoll. We've had him at many DRC conferences. He was the keynote last year. He has some great YouTube teachings on mediation, and he's it sounds to me like he could be a neurosurgeon, which is definitely not me. But he's also an attorney and a mediator, and he believes in helping people, assisting people, all these foundational principles that we're talking about. And the part of the brain, this is how much I remember. The part of the brain, the amygdala, I think that it like hijacks your emotions when you're under stress. And again, the people in your mediation may be under stress. I mean, some of them may show it, maybe others don't show it. But they're super sensitive to partiality and conflicts of interest. If you've ever been under stress, if somebody's ever sued you, I personally have felt that, like your amygdala is being hijacked and you can't rationally think. So that's why you want to kind of put yourself in their shoes about what they be perceived as impartial or as partial. Yeah, we always have to correct ourselves. So here are the complaints on that one. One mediator referred the complainant to a specific attorney. Well, we probably don't want to do that. It's not your job to refer them to specific attorneys. You can tell them, well, and this is out, you're not doing this during a mediation. But let's say somebody's talking to you in the hallway before the mediation, and they ask you where to get an attorney. You could say, that's not, that's just not my role to give you referrals to attorneys. That's probably the best answer, so I'll stop there.
Or refer them to the bar.
Yeah, but that's just not your role. The complainant in this complaint also acted as one of the party's interpreters at a meeting with an attorney. This, I think, was outside of mediation. Entered into an intimate relationship with the party's ex-husband. So then, this ex-wife was the complainant in a grievance. He filed a grievance because the mediator had referred her to an attorney, acted as her interpreter at a meeting with the attorney, and entered into an intimate relationship with her ex-husband. The ex-husband was the other party to the mediation. So you want to avoid those things. In that case, the mediator had a different case. The mediator had a friendship with one mediation participant who was the wife, while assuming an adversarial position to the other participant, her husband, and gave advice and counsel to the wife prior to and during the institution of the legal proceedings. So apparently the mediator had been more of a legal advisor than the wife files, and the mediator still mediates the case. That's a clear conflict of interest. You don't want to do two roles, giving legal advice and then becoming a mediator, because you just can't be impartial if you are doing those two roles. So we're going to move on.
I keep asking myself, what is going through these people's heads when they're doing this stuff? Like
I don't know.
Really?
Well, and that was often the feeling we had as we read these. Really? These people do this? Safeguard the mediation process. What if these are the only mediations these parties ever go to, and now they have a perception of the court system, because they're probably going to think this, the court system ordered us to mediation. Now they perceive the court system this way, and they never want to tell their friends and family to go to mediation because they were treated so badly. So we do want to safeguard the process and the court system, and part of that is the public's perception of the whole thing, mediation in the court system. So yeah, you have to be careful and professional. Marketing practices is the last category I'm going to talk about. These cases, a mediator made repeated misrepresentations on his application for mediator certification, in resumes, on websites, and other marketing materials, implying or stating that he was an attorney, a member of the Florida Bar, a retired judge, and he was none of those things.
She's looking at page 36.
That's a classic case that the DRC had. And you'll find more details on the website. So another complaint was about a mediator who operates a business. It's a business for providing continuing mediator education, advertised a course for concealed weapons permit as an approved CME. In fact, you all know, hopefully, or we keep telling you if we work at the DRC like Kimberly does, that there is no pre-approval process for CME. Once in a while, a provider will contact the DRC and there might be a review in advance, but there's no standard pre-approval for CME. There just isn't enough staff to do that. So the course, and also since it was a course about obtaining a concealed weapons permit, it didn't enhance, it was decided that that course did not enhance a participant's professional competence, the mediator as required for the course to qualify as CME.
Hence, no gun on the table.
Yeah. It didn't constitute an organized program of learning directly related to the practice. Now, if you went to a course about self-protection and security, we at the DRC, we often had speakers who talked about what to do, if a courthouse has a violent act, or how to safeguard a mediation process practically, security-wise.
And you all have buttons in the room.
Right, and those are all definitely qualified for CME, keeping people safe and being alert and aware of what the safety issues are. Those are good. Just not one on how do you get a concealed weapons permit. So those are the complaints on the website. And do you have any other questions? And I noticed, Dave, you didn't schedule any time for break in the agenda you sent me.
Shame on me.
Well, we could give them 5 minutes.
We're gonna figure it out.
I have a question. I have a
Yeah, I see
question.
some hands. You wanna, I can take a couple of questions.
One quick
and then
question.
We can have a break and I'll say goodbye.
One quick question is 2 parts. What's the time frame after the mediation for one of the parties to file a complaint? The second part is, can a complaint unwind a settlement agreement?
Oh, well, there is a time period now. For years, there was not. And that is in one of the disciplinary rules.
It's not in your packet. Part 3 is not included, Susan, because it's the almanac. So, I remember the answer. Do you want me to give it to them?
Oh, yeah, go ahead.
All right, so
Sure.
it's either 2 years from the date of the mediation or 2 years from from the person knowing that a grievance actually happened at the mediation. Say a couple of months pass before an agreement is turned in or something else happens. So it's a little bit fluid, but technically think about 2 years.
I'm looking to see if I can find it real quick. In part 3, like Kimberly said, it's at least, if the rule number has not changed, but I don't think it has, 10.890 as the time limit. Yeah. And you were right, it's not filed later than 2 years after the date on which the party had a reasonable opportunity to discover the violation, but in no case more than 4 years after the date of violation. And just to let you know, the first step of the disciplinary complaint process is that a complaint committee is put together and they meet and they determine whether the complaint even is facially sufficient. That means, does it contain even one allegation that, if it were true, would violate the rules? Sometimes the DRC receives complaints about things that, even if they were true, they do not violate the rules. So facial sufficiency is the first gate that the complaint has to go through. And then it's only if it is found facially sufficient that you would get a letter from the DRC saying, we received a complaint and you here are the details for your response. You have a certain amount of time to give us a response. And then that response will be carefully considered. It would only be then that you would actually know that a complaint's even been filed. If there's no facial sufficiency, if the allegations don't have any specifics in them, if somebody just comes and files a complaint that says, I didn't like Susan Marvin as my mediator, that doesn't say anything that the committee could consider would be a rule violation because it's not specific enough. Or, I felt coerced at my mediation. You've got to give, Susan Marvin said, you must do this, or, the judge will decide some of these allegations that we just read, the statements that did receive sanctions, those were very specific. So if someone files a complaint and they don't give specifics, it's most likely they get another chance to revise their complaint, but you may never even know that a complaint's been filed against you if it's not specific enough.
I have a question.
Yeah.
Years ago, I was advised when issues of like giving legal advice, you could ask the question like, have you considered bankruptcy?
That's
changed apparently. You can't ask that now?
Well, when you're pointing out options, you probably could mention bankruptcy as an option. I wouldn't talk about it alone. If the question to you is, well, what happens after a judgment? Well, there's lots of stuff that could happen. They could get an execution. You could go bankrupt. You could do this. You could do that. But I'd stay away from it if I did.
See an attorney.
Try to avoid that.
Can you ask if you've got attorneys there, can you ask one of the attorneys to please explain the process of bankruptcy? What happens, during bankruptcy, and see what they say, or you want to avoid
I
that
wouldn't
too?
raise it. If it comes up, yeah, but I wouldn't raise it. Susan, what do you think? Kimberly, this is a joint discussion.
Yeah, no, I would follow Dave's advice unless the parties have raised the issue or you're in a brainstorming. Just throw everything on the table that you can think of. I'm gonna throw that back. I am not gonna make a singular suggestion in the form of a question. I would do more have you considered your options today?
Right.
What might they be? How have your friends resolved cases when they find themselves in this situation versus giving the prompt, unless it's a menu, just a menu of things. But the party has legitimately raised it, or you're again in a brainstorming where and again, I want to pull the items from the party, not.
And even if the party raises it, I would maybe say, well, yeah, that's one option you have.
Right. The other thing that I actually think is more plausible in a small claims mediation is where the judge has, the judges do quite an opening statement here, regardless of who they are. They are pretty thorough. And I've never not heard a judge in Leon County talk about, say directly, we will not collect your debt for you. If you win at trial or you make an agreement in mediation, it is up to you to, make sure that money comes into your pocket. So sometimes I will bring up, and what I feel is fair game is, mostly in caucuses, well, you heard the judge's instructions this morning. What do you think about some of the options the judge laid out, including a judgment? Because the information has been given at the very beginning by the judge. I feel like it's fair game to remind them or ask them what they think about those options. So that's probably the only niche. But for example, if I was in a courtroom and for whatever reason that judge on that day did not mention the collections process or whatever, I would not go, hey, remember when the judge said, or hey, most judges will normally tell you this. I mean, and some of you are in attendance in pre-trial and some are not. So again, only, use what you've heard. But that, in small claims, giving information on a judgment, which may only help one party, I'm not really sure. But that might be the only time where I refer back to one particular option.
And you might want to use it when you're talking to the plaintiff. because that's one of the impediments of collecting the judgment. So it may come up in the course of conversation with the plaintiff in caucus.
Caucus.
Yeah, absolutely.
As a
caucus.
reality check.
Definitely a caucus thing.
Right.
Reality check.
Yeah, exactly. So you might want to use it under those circumstances too, but I wouldn't make a big deal out of it.
In addition to the bankruptcy option, another one that has arisen in my mediation is the entry into military service. There is some type of legal loophole that is, and you correct me if I'm wrong, Kimberly or Susan, that if you are about to enter military service, you're waiting to get your papers in another month or two, then somehow you're immune from legal processes.
Not. The Soldiers and Sailors Relief Act will not let you enter a judgment against the soldier if he can't be there due to active military duty. That's about what the Soldiers and Sailors Relief Act does. So, no, it doesn't give you immunity. It just keeps you from getting default against you pretty much.
Now, would you give that advice, David, to a party that you just gave us?
Tell him with the Soldiers and Sailors Relief Act, I would probably look it up and let them read it.
Would you mention it? You're giving advice to one side, really.
Probably not.
Okay.
But I mean, if they raise it and they have it wrong, oof, that's a tough one, you know?
It's a tough one.
Yeah, it's a
It is-
tough one.
It's really tough because you've got to make sure that it's consistent with impartiality and preserving self-determination. And you have to ask yourself, does this information benefit one person over the other?
And that's always gonna be the question you ask yourself. Whether you're talking about issues, anything. The question is, am I helping one side or hurting the other side?
It's definitely not our job to provide the level playing field between the parties. If one party comes sophisticated and one not,
I don't believe that there is a
Can't
playing
fix that.
field.
No. And I can't believe you can level it either. How do you level a dependency case when the Department of Children and Families have their children, you know? How do you level that playing field?
Yeah, you give an opportunity for everybody to communicate, you give an opportunity for people to get attorneys. And I think we're attracted to this profession because at some level we like helping people, but the help you can give them is provide them this environment where they could have power and self-determination and the balance they possess. But, you know, in an ideal world, every person would come with an attorney and the attorney would know what they're doing. Because Dave gave you the example of the attorney who came, but it probably wasn't his expertise to tell his client, you don't have to pay 10 years of back child support. Maybe he took the case, you know, and that wasn't his area of law and he wasn't prepared.
As a matter of fact, that's exactly what it was. The guy was a criminal lawyer, he was a friend.
And it's not your role to make people's experience equal in terms of their legal knowledge and their representation. You provide this safeguarded environment, and we would all love to help people, but this is not the role for that.
And you are helping people. You're helping the
You
court.
are, you're
helping
providing a place,
everybody.
but there's a limit to the ethical help you can provide, and it doesn't involve giving hints, giving advice, and again, you've got to get through that sieve. Does it protect impartiality and self-determination and not favor one party over the other? That's difficult to get through.
Your job is to give them a level playing field and let them play on it. It's their decision, it's your process. Yeah, Tom?
What about, if, say, a clerk has some information about a judgment, you know, it's a document.
You can tell them that the clerk has a very good pamphlet on how to collect a judgment. I think you can give it to them, but I would let them go to the clerk's office and get it, I think, more than giving it to them.
There's a Meac opinion on that, I think. Isn't there, Kimberly?
Well, it relates to in your opening statement and what information you will provide coincidentally about a judgment and It does say that one of the ethical options is if the court has information, whether it's from the clerks or any number of these things, that you could certainly point out or even provide the information that the clerk has as a resource without violating ethical rules.
Susan, go
To
back
both
to your,
parties,
go
yes,
back,
yes.
go back to your vacation. You're not in Alaska, are you?
No.
Oh, it's like 3 o'clock in the morning?
Oh, yeah.
They came here. Well, it's been great to be with you. If you need me again, I'd love to come again, but it's always wonderful to be with the Second Circuit and Grant and Dave. And if you do want to see more about the discipline process, I'm a big seller on the DRC website, as you can tell. There is, Grant played a party. He was very cooperative and wonderful, and he's in a hearing panel demonstration on the website if you haven't watched that. So if you want to know more about hearing panel experiences, hopefully you'll never need one, but there's a little bit of humor in it and it's doable.
And you're not gonna get it here because I'm not gonna talk about grievances either, and Kimberly's gonna give you some Meac opinions, so you're not gonna get it here.
Yeah, it's a painless way to get some CME, probably.
Thank you, Susan. So I guess you wanna give it 5 minutes, Kimberly, to?
Absolutely.
Or so.
It's not a whole process, except as one is before the Supreme Court.
I know what you're saying.
I will tell you that. Specifically,
Maybe you wanna go now and.
use that in your court. So some people have been very clear.
That is a
We're actually, I
You're trying to
am
resolve
this action, the result of this action will be filed with the court and I insist that yes, to vacate. Or they could even say in your motion to vacate or the judgment or a settlement, they can bring up their grievance, right? So, right, so, and, at a certain stage, the grievance is confidential, but once probable cause is found, that means that they actually find an actionable, something new, and it's introductory, then everything is not confidential. So for the beginning of the process, probably are just strings around about what you can discuss, but then after, and I'm sure.
Kim, do you have a PowerPoint?
We have had people ask, I filed this grievance, will I get out of the way? We tell their answer is, that's not up to us, suddenly the grievance is I know, isn't that a wonderful answer? I just need a corner of the other than that, and I'll have to negotiate him for that.
I'll give you 2 tables if you want.
No, not really, I just need a place to set my folder, but if David's okay with that. Okay, maybe, it's good to see you both.
Thank you.
That way, I'm trying hard.
Okay.
Certification expired.
Okay, April of this year. Okay.
You know this.
How are you doing?
Oh, I'm sorry.
Where was it? Yeah, I'm on
Okay, we're recording now, so if you're talking about something, don't let everybody.
Just keep yourself going. Just keep moving.
All right, let's get together.
So we probably are very close, if not.
You can email me and I'll walk you through the rest of the discussion.
I'm gonna introduce Kim Cock. She does not need an introduction, you all know who she is. You've all heard the adage that chief petty officers run the Navy. Well, this is Super Chief Kim, because she runs the DRC.
Oh, that's so nice, Dave. But actually, the glory of my position is at the DRC is that I'm not responsible for it. We have a new chief. His name is, may I borrow some space, David? Okay. We do have a new chief. Regrettably, Susan retired, and Susan told us about her retirement at a staff meeting halfway through the meeting, and all of us literally froze. We were on Zoom, did she say that? In April of this year, this year? Oh, and I think it was almost like collectively we were shocked with a cattle prod. I mean, honestly, and she had this wonderful opportunity to help raise her grandson. What grandmother would pass on that? I mean, I would raise Susan's grandbaby for her. So who can begrudge someone who's spending time with family? I will tell you, I really appreciate you guys, but you wouldn't get an hour of my vacation time. And I'm pretty sure she's at St. George on the beach. So just know how much Susan really loves you and cares about you and how much she thinks of Dave. And she did a wonderful job, great prep. So let me take back a step though. If I hadn't interacted with you before I got up here, I was going to say how wonderful it is to see you all. I mean, it's been, I still get to see some mediations and some colleagues on Zoom, but I am really committed to live and in-person training. It's where I feel most comfortable, where I learn the best. I think both, doing some webinars and doing some in-person is a wonderful mix. So I'm glad that you turned out today for the training. And again, thank you for all of the services that you provide to the courthouse, to the state of Florida, to the larger ADR community. Small claims and county mediation is the largest area of referral for court-connected mediations. I don't know if you know that or not, but the county court small claims surpasses family dependency and appellate court-ordered mediations. You probably mediate more than the average mediator when you come once a week. And are we still going to do once a week, Dave?
We are.
On Tuesdays,
Yes,
same that place and time?
Same place,
Okay,
same time.
all right. And
Line
you're,
up all the usual suspects.
all right, and you're live and in person now or soon?
No, we're going live on May 3rd.
On May 3rd. Okay, great. Well, I can't wait to be back with you. As a trainer, I need to either mediate or observe so many cases a year, and I've been doing that around the state, but nothing is like being at home. So I'm thinking Dave might accept me back. So right. All right. Well, I'm actually, Susan's lecture was a great place to start this morning because she really kicked off what you need to look at in terms of the rules. And I know that Dave's going to be speaking after lunch on the rules. So you're going to get a lot of information. I'm talking today about the Meac, the Mediator Ethics Advisory Committee. And the Meac is a 9-member committee statewide. Members are appointed by the Chief Justice of the Supreme Court for 4-year terms initially, and then can serve up to 8 years. Most of the members, believe it or not, asked to be reappointed after their initial term is up. So many of the members end up serving an 8-year term to assist. The Meac takes in questions from certified or court-appointed mediators and publicizes those opinions for the benefit of all mediators. So we're going to be looking at the Meac opinions from 2009 through 2021. We're only a couple months into 2022, and the committee has not yet rendered any opinions in this year, which is actually not so uncommon because it usually takes between 90 to 100 days for the committee to officially release an opinion. And I will tell you that we have, some years we get a lot of questions, and some years we don't. The committee only does what's before it. You have a summary in your packet. I know you have a fancy pink piece of paper, and then behind it you have the Meac mediation summaries, 2019 through 2021. Now, I did not make copies of all of these opinions. It was about 50 pages, and quite honestly, that was a lot to copy in the days of, more posting things on the web. All of our opinions are posted on the DRC website. Susan mentioned several resources. I've mentioned a couple of things. If you haven't been to our website, it's a really robust place where we contain a lot of different information. So, and if I know you're going to be provided a lot of information today, my email, in case you want to write it down, is Kosch, my last name, Koschk, at flcourtsplural.org. So I am easy to reach. If you want it, if there's something that you say, oh, she mentioned that was on the website, but you can't find it or would like some easy access, just email me and I'll provide you the link of where you can find whatever you're looking for. And as a reminder, if any of you need information on, oh, there we go. It's Resources and Services, Dave.
Okay.
And then there we are at the top. And then you'll see listed right there are the Meac opinions. I appreciate this, Dave. This is really nice. And you'll see that we have them broken down by 6 areas. And we also have them listed by year, just straight year. So that, and also an index, I kind of shortened it for this year, but a full index of the opinions. So there are over 250 ethical opinions between all 6 of these topics. So you can see how they're numbered and how they're available by topic area. So, and if you call the DRC for advice and you happen to get me on the phone, the first thing I'm going to say to you is, well, I'm pulling up our website to see if we have an opinion on that already. Because after, I think the committee's been around about 28 years now. We have a lot of opinions out there, and hopefully we can just provide you with what has already been asked and answered. That'll be, the quickest way for you to use a Meac opinion is we have something on topic. And if not, even though I might discuss some rules with you, I'd always encourage you to submit your question to the Meac, because if you have a question, somebody else probably in the state does.
I have a general question.
Sure.
Is compliance with a Meac opinion a defense to a grievance?
Well, it's not a get out of jail free card, but it will be considered as mitigating circumstance.
And how many times in your career have you ever nailed somebody for following the Meac opinion? Has the committee ever grieved somebody who followed the Meac opinion?
I don't know that we've ever had a case. Now, I'll say that with an asterisk because I don't staff the disciplinary process and it is confidential. So we do keep those materials only between the people who need to know them and literally in a locked cabinet in our office. So I woun't know, but all of the public information is on the website, like Susan mentioned, and I've never seen that in a case file.
And that's my point.
Yeah. And I do talk with people who have read Meac opinions, who disagree with it and do whatever the Meac is saying. And you just need to know that someone else has a different train of thought. They are advisory, so they're not leveled to rules, but I just would have whatever you're doing, if it's not following and going exactly the opposite way, that you have a rationale for your behavior.
I have disagreed with Meac opinions. I have followed those opinions.
I am in the same boat.
Are
Larry.
there any two Meac opinions that contradict each other?
There are Meac opinions that could be read where you think, this one's a little sideways given what the Meac has rendered before. I also tell you that there's an evolution of thought
That's what I mean,
in my opinion. So if you read some of the conflict of interest opinions, that's where I see a move toward less clear conflicts and more a default to disclosure, and if the parties are okay, moving forward. So some of our older conflict of interest cases, if you read just some really old ones, you would get the opinion that you could never work with an attorney, for example, who was in a mediation before, or a repeat player. It's just a lot stricter of a reading of our rules. And our rules actually didn't require such a strict interpretation. So there has been some change. Most opinions that seem to counter one another actually come from rule changes. So for example, back in 2004, the confidentiality statute, when it was put into place, made some actions now prohibitive. So if you read any Meac opinion before 2004 in confidentiality, you'll notice that the statute is changed, and specifically the big one used to be that there was no prohibition about reporting to the court that the parties lacked settlement agreement. So if the parties lacked it, the mediator could go out and report to the judge, hey, ABC Corporation's representative didn't have full settlement authority. Well, now you probably, I would hope, all know that that type of communication is a confidential communication, and there's not an exemption to confidentiality for the lack of settlement authority. So that would be an example of something where the rules changed and then the Meac opinions changed in accordance.
And generally, the opinion will tell you that there's another opinion out there.
Yes, we always, if you'll see, we'll get through the summary and we'll reference some others in a minute. Grant?
What's the position on reporting non-appearance?
Non-appearance because somebody
Particularly-
physically didn't come?
Well, it's unlikely that that's gonna happen. It can happen. I think I had heard of people that.
I'll tell you what my
The
policy
judge
is.
appointed, sent them to a mediation and they never showed up. But it can happen with telephonics all the time.
My policy is, if you can see it and not hear it, you can report it, like non-appearances. If you hear it, it's communication and you can't report it no matter what, other than the exception.
Right.
So, is that right?
Yeah, and one of the opinions we go over will actually cover some of that. So if you're ready to look at the summary, I have a few that I had picked out we're going to start with, and then if time allows, we'll jump back to some others. So the first one I'd like you to look at, luckily, is the very first one, 2001-011. This one says, this opinion was asked by a county mediator who actually went through a DRC county training, fairly recently. And she asked me, hey, is it okay for me to put that I'm a Florida Supreme Court certified mediator in my signature block? And I thought, and she's a court employee. My first said, well, you need to check with how your supervisor feels about that. And then I said, honestly, what's the purpose of you doing that? I asked that because I thought maybe the purpose might have something to do with whether it's acceptable or not, but that is a great question. And actually, I'm not going to give you an answer. I'm not going to, when just talking in class, I said, that's a great question for the Meac. Because honestly, I thought it was okay because it's true and accurate information, but the Meac is made up of 9 individuals. And I will tell you, 9 individuals' thoughts and contributions are usually better than just one person, including myself. So if you are inclined to, I don't know if you're advertising or just want to include that. If you have a signature block on your emails, it's totally acceptable to do that. I have not changed my signature block at the court based on this opinion. My certification isn't something that I actively use, or it's not really related to a lot of my job activities, so I've just decided to keep it kind of simple and short. Grant?
It did change while I've been mediating, that you have to list, if you have a certification as a county court mediator, if you're putting it in a footnote or a block, it has to include what type of certification you have.
That's exactly right. And that's also, it's in a rule and it's in a Meac opinion that you must identify at least one area. So if you are just not advertising, again, placing words on an announcement, an email, or your website that says certified mediator, and I know a lot of people do that because it's honestly, it's simple and short. Fits on a business card nicely, but the correct advertising marketing rule says that you have to identify the accrediting agency and you must identify at least one area of certification. So depending on how many certifications you have, that might be a lot for a business card, maybe not a lot for a website, but you must at least identify one area. Okay, great, thank you for that, Grant. The next one I'd like to look at is 2001-009. And you will see that in the bold heading, there's a heading and it's in bold. I just put what area, if we were looking at the 6 different areas that we have our Meac opinions on our web divided by, I put for you where this opinion flows, and that's what the pink paper is. The pink paper is kind of a guide, a visual to show you how many opinions over the last 2 years have been rendered in any one particular area. And procedures and reports to the court has been a very heavy area for us over the last 2 years. We do seem to get similar topics that kind of dominate for a year or two, again, especially if there's a rule change. But then I do want to point out to you that we have an authorities referenced, and the authorities are what rule, statute, or Meac opinion did we take away anything from those rules. So almost all of our opinions have a mediator rule reference. Some of them have statutory references, and some of them have past Meac opinions. So if you look at 2001-009, you're going to see over to the side that there is an opinion, 2017-006, which is either on point or might be duplicative of the question that would answer. So on this one, kind of going to Grant's question, not directly, but on the same side of the issue is that in this particular mediation, the attorney reported to the mediators that the case was settled prior to mediation. However, the agreement never showed up in the court's email box. So the mediators reported it as settled prior to mediation. No agreement has come up. And now the mediator interacting with the court feels like, whoa, what should I have done? Should I have submitted something to the court that said that mediation wasn't held or something else because the agreement never showed up? Now, settled prior to mediation is one of the checks on that circuit's outcome form. So it wasn't that the mediator hand wrote this in, and you have to assume that it was a mediation not done at pretrial conference or it was small claims or scheduled. I don't really know I don't remember the case type for this case. The mediator asked, would it be appropriate for me to amend the report to show no agreement? And that does the mediator have any other further obligation to report? So the answer on this one was a little bit long. If you look back at 2017-006, the opinion is more direct. And really the takeaway on this one is if you do not conduct a mediation, it's not appropriate to submit to the court an agreement that says impasse, no agreement. Because in order to do that, there has to be a mediation proper. So I'm not a fan of the checkbox settled before conference. And if you've read other Meac opinions, it seems like that is a tricky thing to report to the court, because there really is no allowance from confidentiality for you to make that type of report. The better way for a mediator, I believe, to report is that no mediation occurred. And that's what 2017-006 kind of sets out a little bit more succinctly. And it may be that you don't report anything because you didn't do the mediation. But if your court has, has a case management system where they want to know the outcome of every mediation, even though it's not a checkbox on your form, in small claims court and pretrial, where they go right from pretrial right to the mediation, I've never had a party run out and exit. I have had to chase down a smoking party outside, but never have they really left the process. But I guess they could dart out a side door and you don't know what happened to them, but somehow you lost the party and they're nowhere to be found. But in small claims, that probably doesn't happen a lot. But on scheduled mediations or mediations that are done in the private world, it's not so unusual that the parties schedule a mediation and then for whatever reason, including settlement beforehand, might not need mediation services. Bart and then David.
Can we just take the word of an attorney for one party that the case has been resolved and no mediation is necessary?
Before a mediation occurs, if an attorney calls you and says the case has been settled, I would probably take that attorney's word. Would you, Dave?
Yeah.
Yeah, okay, I wouldn't need to back call the second party.
Right.
However, you still need to know within 10 days of that mediation if there is an agreement. It doesn't say that you have to know it or inspect it, but you need to have some way, if you're doing mediations and you're in the private world, to follow up on that 10th day. And it might even be you calling one of the counsels, has the agreement been finalized?
We don't need to do that in this.
No, you've got somebody like Dave who will do that. But if by that 10-day mark, the attorney says, no, we're still working on it, well, there's some other things that you can do, but eventually there's a time limit. And you might be reporting a case as no agreement, even though they're working on one, but it's just not finalized within that time frame. And COVID, just to kind of put an asterisk on that, doing virtual mediations, and if you've done them, and I'm sure many of you have, getting the agreement signed, which was such a simple act usually at the end of the mediation, has now become a separate and distinct procedure. And there are many cases that are going back on court dockets where the parties walk in with the agreements. They thought they had filed it. They thought they had signed it. They never got it. Whatever the reason is, courts around the state are dealing with how to get those agreements back after mediation proper.
May I tell you our policy?
Sure.
My policy is when you are waiting for signatures, don't report. If they haven't signed it within 5 days, call them and see what's going on. And then at the end of that 10-day period, report no agreement. Because I don't want to adjourn a bunch of cases and clog up the court calendar if you're just waiting for signatures. And that's the reason for that.
All right, but Sharon had her hand up first and then I'll come back to Tom.
Yeah.
Is that right? Did I skip anybody? I skipped John.
David.
David, I'm sorry.
It's okay, you've answered my question.
Oh, okay, great, even though I called you the wrong name.
Yes.
But I got it right the first time. That's gotta count for something, right? This is being recorded, Dave? All right, Sharon.
Okay, and this just brings up something, I don't know, it's very closely related to what you're talking
Okay.
about, that I have a big problem with, that
Okay,
I have seen so much here. And everybody knows what I'm about to say.
okay. I don't know if I do, so surprise on me.
Well, we have an attorney Black, and I just put his name out there, who mediates before the process in the hallway.
Okay,
I've brought this up here before, and supposedly they talked to the chief judge, it's okay, but I can tell you I know it's not. But anyway, that keeps happening. He goes, he's talked to them before we even get to mediation. One lady even passed out here before, she was so nervous about it. We talk about the deers and the headlights. surely that lady was afraid to come in here and have that happen. Then we go in the room and he says, we've already talked. I won't mediate with him because I think that's unethical.
See, that's the question I asked.
And so I know that's what he was talking about. We all have problems with that.
Okay.
And one day, and like I said, it keeps going on. And then one day, he had a case and he tells the judge, oh, we saw that. And where's well, I told her to go home. He told him, don't you ever do that again. And it's the same thing for us. Why is he talking to people in the hallway?
Can't stop it.
Before,
Under the
no.
bar rules, you can speak with someone about
But
the
he's-
subject matter of the litigation so long as they are not represented by counsel.
But he's doing more than talking to
Well,
them.
look, when they come in, if he says, we talked and we settled the case, you look at the other side. Is that true?
We don't get the
We
other
don't see
side.
the other side.
Well, then.
I'm just telling you.
What do you
it's-
mean you don't see the
They're
other
gone.
side?
He tells him to go home.
You can't tell him to go home. Unless he's got a signed paper, you can't tell him to go home.
That's why I asked, can we take the word of an attorney
That's
for
where he's
one
coming
party?
from.
and
Okay.
Saying that it was settled before it gets to mediation.
Right, and I did not know that you were talking about in the environment of mediation. This example, mediation scheduled 3 days from now. The attorney calls you 3 days from now and says, hey, take us off your calendar, we've settled the case.
What's the difference between 3 days and 3 minutes?
Right.
Well, but for that one hasn't gone to mediation. In this one, in this example, you're telling me you only have one party. So there's already a question about whether or not you can mediate. Can you mediate with only one party?
No.
So,
No.
no. So I don't know exactly why Mr. Black is referred to your mediation to begin with.
were talking about?
Huh?
Do you know who they were talking about?
I put it out. We don't, because we don't.
I have
I knew who you were
secret
talking about.
cameras around the building,
You
Tom.
do have a remedy, because one of the exceptions to the confidentiality rule is misconduct of a party either on or before mediation. So if you got a really heartburn over this, grieve them with the bar.
Well, you
No,
can
I
grieve them
just-
with the
but I also-
bar, but just to the bar. You
Just
can't
to the
put, you
bar.
can't put a billboard out that says Attorney Black sucks.
But if I can't be impartial, and I
Well,
can't be
you can
impartial, I don't need it.
Right, and that's
I
another
do
thing,
not
that's
need it.
another thing.
I
If
won't
you
do
know that you cannot be impartial to a subject or to a personality, get out of it,
Get
don't
out,
take it.
withdraw. Don't even think
Withdraw.
about it.
I
If
know.
you even think that you have a problem enough to withdraw, you have a problem enough to
So
withdraw.
all we
Get out.
all have to do is say, don't do his, and then we'll solve that problem.
Well, no, but let me tell you,
I
that I didn't know, this particular dynamic. I'm excited to get back to county court. I'm here on the first Tuesday, the doors open. And all of a sudden, I get this case, they call, you gotta come up to the second floor. There's some amount of talking time you have, and I say, oh, I guess Mrs. Smith didn't get on the elevator with us, or I thought she was the lady who was on the elevator, lo and behold, it was a wrong assumption. And we get to the door and I've only got one party, I'm not opening that door.
And
I'm
that's
not
legal,
going in.
because now you gotta report that the other party didn't attend mediation. And they've been ordered to it. I mean, this is a big problem. I need to deal with this. I will.
Right,
Yes,
Yes.
you do.
Yes.
Yes, you need to deal with it.
I'll deal with
right,
this.
right, or
Thank
bring
you
them,
for coming and for getting some support for it, because we all don't like it, but and some of us talk among ourselves. But it's more than just me with the problem.
right, and I will tell you that Leon County is not the only county that has attorneys that do this. And I can tell you that time and time after again, chief judges or administrative judges who are ever in charge have stood behind attorneys to talk to clients about cases. So there is no mediator preference here. Attorneys are allowed to do it. I have not met a mediator who likes it, Sharon, at all. I have not met attorneys that do that, but I will tell you, years and years ago, I mediated in Gadsden County fairly regularly. The program was new. We only had like 3 or 4 volunteers that were going out there, or specifically designated that lived out there. So I mentored a few people, and and frankly, Gadsden County is closer to my home. So I would enjoy going out there. And gosh, love him. The judge who was on there for a long time before Judge Gardner, and I forget his name at the time, would say to the parties, well, if someone walked in and said, yes, Your Honor, I owe the money, I'd like to make payment plans, the judge would regularly say, go over and sit on that bench, see if you can work out the terms. You find you can't, let me know and I'll assign a mediator. So honestly, we only did very few mediations out there. I'm not sure if that's still the landscape now, but the judge was actually, encouraging that and only sent to mediation in the cases where the parties said, no, I don't owe the money, or the dreaded, I owe some but not all. And I'll tell you, I hate those words in open court, because to me, those are more difficult. Even the people who do the posturing and say, not a dime, not a dime, not a dime. A lot of that to me is theatrics for the courtroom proper. You get upstairs and there's, they're willing to negotiate, but the some not all ones are, I think those are a little bit more meaty. Wait, did I go? No, Tom, Tina, and then Larry. You remember the order, okay? All right, Tom.
Okay, question for either you or David. A court-assigned mediation, doesn't matter if it's civil or family. You come to an agreement, and you are told that doesn't matter, plaintiff's attorney will do the agreement. The report that we file is the parties reach an agreement, a copy of which will be filed by the petitioner, plaintiff's attorney. When does our responsibility for that end? At that point, or do we need to keep track?
The rule says a mediator is responsible to see that an agreement is promptly filed. Now, that doesn't mean you have to do the agreement. That means you have to keep an eye on it so it's promptly filed. And what's promptly filed? 10 days, I guess, is a good number.
It is 10 days, but let me challenge your statement a little bit,
All right.
Tom. And I'm gonna go back, I'm not challenging you
If
yet.
you're talking about what you can and can't report, this is what it's
Right,
hard.
yeah, page
I got
13.
a problem with the report.
Oh, okay, page 13. Let's look at page 13, rule 1.730, completion of mediation. So,
Agreement, no agreement, adjournment, and that's it. Without further
Partial
comment.
agreement.
Tom is citing the rule before even we've all gotten to the page numbers. All right, so what I will tell you, this is the civil rules of procedure. So we have a part about no agreement, and then the imposition of sanctions. So, Tom, I would tell you that I would report, I would hold for the 10 days. I would, because reporting that there's an agreement and the plaintiff will submit the agreement. Who is going to submit the agreement? I'm not 100% sure that's without recommendation or comment.
I think it's a comment.
It's a comment to me. So really there are some things that you can put on the mediator's report other than the check mark. But the check mark is I have never found myself writing anything on the outcome form other than agreement, no agreement, partial agreement. If the mediation is continued, which does that mean adjourned for you?
Yeah.
Okay, so I like the word continue because in the rules we use adjourn and terminate really to mean to close the mediation. So I'm always very clear because adjourn is not defined in our rules, and I think I'm in the minority when I think that means it's over, but continuance, you can report to the court that the mediation has been continued, and I think you even have a line to write in the date and that really serves as notice
Use that
as
date.
well.
Use that date because you don't have to renotice the mediation. Put it
Yes.
on the agreement or on the report.
Right.
So for the case of here, can we hold the
I would-
agreement, the report for 10 days?
Yes, hold the report. The longest you're gonna hold the report is 10 days.
Calendar days?
That calendar days, probably not, probably work days. Under,
Well,
no,
it just
calendar
says,
days over
it
10.
says 10
Yeah,
days, and the court has largely done away with, quote, business days, because legally there is a way to calculate time in the court system, and it becomes a real problem when, for example, our Chief Justice in the Supreme Court can give us 2 discretionary days off every calendar year, and a lot of the trial courts follow that same. So recently, were the courts closed for Good Friday?
don't know.
Oh, yes, okay,
I'm
right.
closed
So
on
you were
Friday.
closed, but let's just say the Supreme Court closed, but your court was open. So then calculating business days becomes somewhat problematic.
The
Or,
rule is if it's 5 days or under, you count weekends and holidays. If it's 5 days or more, you don't count weekends and holidays.
okay, so I was gonna say, I would use the strict 10 days. And I wanna point out for those of you who mediate in family, how many of you mediate in family? Okay, just know that the procedural rules belong to the case type in which you're mediating. So what we're looking at in page 13 are the civil rules. They go over civil cases. But if you fast forward to page 23, page 23 has the report, what's required in a report for a family case, and those rules are slightly different. In the family rules, there is no time frame mentioned. In the civil rules, it says 10 days, but you'll notice in the family law, there is no date proper. So many courts have their own local procedures about when the agreement is filed. I'm not sure what your time frame here is now, but just notice that whatever area you're working in, and that's why we produced why I brought the almanac with me rather than the Mediator rules booklet, which just contains the Mediator rules, because there are other procedural rules that you need to follow, as well as some statutory references dealing with largely confidentiality. So who was after Tom?
I was.
Okay, Tina.
And really it piggybacks off of this. I think the answer is probably obvious, but I just want to make certain that I understand what we're talking about with waiting for the signatures and not filing the reports for 10 days. That does not pertain to small claims on Tuesdays, right?
It does.
Yeah, county court does.
So when we are mediating on the phone and we send the agreement that we prepare to the staff, and then staff sends it to the parties, because we haven't been emailing the agreement to the parties.
That's because we're taking care of it.
Right.
Administration is taking care of that. Your responsibility ends when mediation ends.
Okay. That's
We
what
are
I thought.
responsible for that.
So, and I
My
can't
question.
tell you guys how fortunate that's
Yeah.
the answer, because sometimes that's not the answer even in an organized program. But again, if you're not in an organized program with staff doing things for you, it's up to you, the
So
mediator,
the
to do
staff
that.
has the 10-day responsibility, not us. We send it to, okay. That's what I thought.
Contractors are different rules. Contractors need to make sure that their agreements.
So
are signed.
there's no responsibility on the mediator to follow up within 10 days to see if they had clicked the signature.
In
That's
small claims court, no, there's no responsibility. But the new process, the new procedure is gonna be, if you're mediating a case on Zoom, and I'm gonna try, even for the small claims, I wanna try to get them on Zoom. We're gonna give you all the sign-in things and all the accounts you need to do that. But when you're waiting for signatures, keep them on the phone. Don't let them out of mediation until you get, when you're doing it live, you go do the agreement, you come back, everybody signs the agreement. I don't see any reason why you can't do that on Zoom or on the phone. Don't let them off until they sign the agreement. That should solve the problem, maybe, I hope.
When we get to that, can we talk about that some more?
Absolutely.
Because I think you're gonna get.
My presentation, we're gonna go all over all this
I don't
stuff in
think we
depth.
wanna do that.
And let me tell you my own personal experience. What I call the Iron Curtain came down in my world on March 9, 2020. We were at a trip. We were out of town at a staff meeting. Susan and I were, and it went till 5 o'clock. We got a text from the head guy over our unit at like 3 p.m. If you have anybody in these certain medical categories or who have compromise, do not come back up to the office on Monday. And then within that week, I think almost the whole force that wanted to work remotely was able to. So I was telling Tom back there, when Susan Marvin told me we were doing training on Zoom, I almost bust into tears. I just found it, quite honestly, overwhelming to learn how to use, I could barely use a PowerPoint in training. So to have to learn to so we took our baby step into Zoom, and we quickly realized that, wow, we could reach a lot of people with 1 hour webinars. And normally when we went to trainings, we would haul our cookies all around the state. We would be there for 4 to 6 hours giving live training. I definitely hope we can incorporate that back, but that's probably not going to be our own sole method of doing training. I hope we keep it though. So in 2 years, literally 2 years, well, it probably didn't even take me 2 years. That's just the amount of time we've been doing it. I went from, please, Susan, I will take a pay cut. Don't make me do this, to, hey, well, I got an idea for our next webinar. Now, I've also been observing mediations around the state on whatever platform they were using, whether it was Zoom or some were on Teams and some on like a Cisco system. There have been other things that have been employed other than Zoom, but Zoom seems to be the default. After observing a few of those online, I thought to myself, I could do that. It really isn't as overwhelming, and actually Zoom has a lot of benefits about dealing with people that take away if there are safety concerns or other concerns about the parties being in the same room. You have the ability to have more breakout rooms than you're going to get in a small claims session, probably. You could have 2 or 3 breakout rooms on Zoom. Right. So if any of you are thinking about it and are nervous or have any amount of anxiety, let me just tell you from my own personal experience, it's not as hard or as overwhelming as it looks. And you might actually find that you prefer it over in-person mediations for some cases, not all. And I'm not surprised that small claims is kind of in the state of Florida the first to go back to in-person, because most ADR processes are still in family and dependency being done on Zoom, even if the courthouse has reopened, because of the increased participations of the litigants, especially in dependency mediation. Across the state, the attendance rates at dependency mediations, because that's a real large multi-party. How many parties do you usually have, Dave, in a dependency?
The most I had was 15. The least you gotta have is like 6 or 7.
Right.
You gotta have the parents attorney, the department attorney, the guardian attorney. So there's.
Right, so just imagine one person doesn't feel very well, whether or not it's COVID related or it's sinuses. You wake up and you think, oh geez, I'm running a slight temperature. I can't go in. There's 8 or 9 other people. And you can sit on Zoom and have the sniffles and it be okay, and you not contaminate anybody else. So
I'll tell you how I became a believer. I had a 5-minute hearing in Broward County. That's a 3-day hearing under normal circumstances,
Yes.
which in fact took 5 minutes. It was great.
Yes, and it does have an impact on the litigants, because Dave, if you were an attorney representing clients, they're paying for that time and not paying for 5 minutes. They're probably paying for your travel time and all of that around. And then that cost is the litigant's cost. So in some places, again, it has really increased participation.
And also it solved a couple problems that we had with telephonics, like being sure that they're the only people in the room on the other side. You know that now, and you can read body language a little bit. It's got a lot of benefits. I still like live there.
Right, hang on, Larry, I think Grant, were you next?
No, I think.
No, that's why you're raising your hand, Larry. And wait a minute, before you ask your question, I remember when Larry was the new kid on the block. And I look around the room and I say to myself, I know Larry was certified pre-2000 because I can remember him attending our conferences before CME was even required.
He's been here 30 years, I think.
Well, that's what, how many?
Yeah, I lost track, but a pretty long time.
Yeah, honestly, I think you were certified in 96, 97, somewhere around there. So okay, you were certified in 92, so I just want to, and I thought, Larry, there might be someone with more service. I didn't think that Larry was the
No, Grant.
oldest. Oh, Grant is, well, Grant looks it, Sharon does.
You need to watch out for your appearance
You
of being
know that I
impartial.
must love Grant to make fun of him on camera, so.
Let me tell you a humor story. One day I was doing a presentation and somebody came up with a question about who do you trust and all that stuff. And just the first thing that popped into my mind as a joke, I said, never trust anybody with a bow tie. Well, everybody thought that was funny except Grant, who was sitting in the front of the row with a bow tie on.
And he still doesn't think it's funny.
All right, so Larry.
Well, okay, I just wanted to get to the bottom of what Sharon was asking a minute ago, and find out what, is there an official opinion that you guys have as to what should our procedure be if we get to the mediation and we're told by the attorney it's already been resolved? Should we just not do anything, not file any paperwork, just tear our paperwork?
I'll tell you what, you come to us. We're gonna be here at every meeting, and we will go online and see if there's an agreement on file. And if there's not an agreement, then
what?
Then you,
Well,
then
it's
I think.
It's not it's on file, that's not the situation, David. Is he comes in at that moment.
I know,
It's not
I know,
on file on the
I
computer.
know. And my answer to you is, I don't have an answer yet, because it's really a bad question. I mean, no, it's a great question with a bad answer, and I will get some judicial opinions on what to do.
Right, and what does he tell the judge? Because normally what will happen, and you've seen this, is if the case is settled, the person at the podium says, Your Honor, we filed an agreement this morning. Your Honor, here's our settlement agreement. So the fact that an attorney would appear at a mediation to me without the other party and say there's an agreement, I mean, caught off guard, I might say, well, great, let's go tell the judge that.
And you know what? Those are the cases that I want you to terminate to me. Now, let me explain to you what I'm saying. You cannot terminate to the court. You report no agreement to the court. But I want to know the cases that there's a fatal flaw in it, that it's not your guys' fault, because you guys shouldn't be in an impasse for a terminated agreement. If you terminate them on that basis, tell me about it, because I can tell the chief judge problems. I can't use specific cases, but I can use it for reporting purposes and there's a few things that you can use that kind of stuff. I saved the mortgage foreclosure cases here, the program, because most of the banks were impassing cases because they hated the mediation requirement. And those that were terminated because the attorneys the attorneys would say, report an impasse, even though the case was settled. And I'm going to terminate that because they didn't want it on paper. And I was able to report that to the judge and save the unit.
So you want us to actually write terminated on the paper?
I want you to write
Send it
no
up.
agreement on the paper and tell me it's terminated by some other thing.
Oh, so you want us to write no agreement on this thing that he's already said he has an agreement for?
No, on that one, I would write no mediation.
That's what happened.
Okay,
There was
so
no mediation.
is there a place to write no mediation?
Write it in. You can report.
You
That's
can
what it
report
is.
that
Okay.
there is a Meac agreement. Actually, there are two that are on this summary. That if a mediation is not held, you can report to the court that there was no mediation held.
That's the simple answer to the question that I was asking.
Yeah.
Thank you very much.
And so if the attorney was correct and they had cut an agreement and he sent the defendant home, and he did in fact afterwards turn in an agreement to the courts, then the courts are all okay, they've got our no.
Well, a mediation hasn't occurred, but the parties have still settled the
Right.
case. So just imagine, he should have, the better process would have been when he was called up to the podium saying, Your Honor, I have an agreement, and submitting it.
And that would also avoid the problem of you having to report that the respondent or the defendant was gone and he didn't appear at the mediation.
Yeah, the problem is he comes up he's like the first one up there and he lists off 20 different cases he has. And so, then, when you go, you've got yours, it's maybe 5 or 6 down the road, and when you go get ready to do yours with him, he says, oh, that one's already settled. I bet that's basically how.
Well, and there's another thing I'm gonna do. I'm gonna assign one mediator to Steve Black. In
Well, and
other
that's-
words, the same mediator's gonna.
Who's gonna take that one?
I don't
Yeah,
know.
no-
I
Nobody
wouldn't
wants
mind, because I don't see a problem, personally, I don't see a problem with him settling before. I really don't see a problem.
I have a problem with Steve responding. I got a
Oh,
problem
yeah,
with
yeah,
that.
yeah.
But you all, what happens when he settles it ahead of it? A lot of those clients think they have to settle with him. They came here for mediation, and they don't get a mediation when he goes to them, and that is just
Well,
outside
that's
of what
the
we're doing.
point.
There's so many things, it happens lots of ways, not just one way. And then sometimes you do get to mediation in the room, and then he lets you know, it's already settled, because he wants us to do an opening statement and for us to put our, it's settled. There's a lot of things going on.
And by the
wrong.
way, if
It
you don't
happens
do it-
lots of ways.
If you don't do an opening statement, you report no mediation.
Yeah.
Because the opening statement,
But he lets.
actually, it doesn't start
uses us
mediation.
to do that.
Confidentiality
Well, it's paper.
attaches when the
If you
order
go
is
to
signed,
mediation.
so there's some stuff you
Yeah,
can't
and
report.
maybe since you all know this and you get your 5
Yeah.
cases, maybe just until Dave has the opportunity to work out whatever he's gonna work out, you ask him at the beginning, which of these cases needs to be mediated, Mr. Black? And I hate to use his name on a recording, but it's out there. And then you will know, okay, well, we're mediating one
He
of
knows
these
that we don't like
cases.
it. He knows that we don't.
Right, well, I would ask the question out front, which of these cases has already settled?
Yay.
And you know what, I was trying to finish before this wonderful person arrived. But, trying to stand between the mediator and the food on the table is.
so keep going.
All right, well, let me move on to, not on this opening page, on the second page, 2001-003. You can find that, it's at the top of the next page, 2001-003. This agreement, Meac opinion is quite clear and concise, that parties that sign electronically it will be accepted in the same way as a wet ink signature. So there is no difference. Now, whatever reporting system Dave has for the agreements, like for example, if the court was to adopt Sign Now or any of those other platforms where you can send agreements, I don't even know that there's a way to download it and physically sign it. You would be signing it, electronically. Sometimes they have the platforms where you sign with your pen or your finger on a pad or something like that. So just so you know, that the electronic signatures are accepted in the same way as a real physical wet signature. Then I want to look at 2021-001. This opinion, it doesn't really give you a lot of facts in the summary, but this opinion, now I will tell you, there are things that, like grievances, sometimes we chuckle at, but this opinion was written in by a mediator who is also an attorney, and said he was writing in as an attorney, but he is a mediator, so he wanted to know the rules. And he asked if it was appropriate that an HOA, Homeowners Association, was a party in a case. The attorney wanted to be able to include several of the HOA members of the board, whatever that official term is, in the Zoom mediation, but not tell the other side, and asked if that was okay. And the Meac came out and said, no, you can't have hidden participations. The other people in the room have the ability to say no to extra party participation. How could they even make that decision if you're not telling them? And then there's a whole host of problems with confidentiality, depending on what happens with this information. So I don't know that any of you will be asked about hidden parties, but I will tell you, I told you I was observing all over around the state. I observed in the 8th Judicial Circuit, Alachua County, Gainesville, on Friday. And despite the mediator's good opening and the judge's wonderful opening, at some point in the mediation, and again, I was just observing, there's a voice that's talking over one of the participants, giving that participant helpful advice. So this isn't anybody guessing that there's an extra person in the room. This is knowing it, hearing them, and the mediation was between two gentlemen, and it was obviously a female voice. So the mediator did a great job about, asking who was there. It was the person's spouse, which is a common assumption. But it does underline that even with good instructions, and it really was, I don't think anybody mistook it as something mischievous. They really didn't understand, kind of like, well, if we're paying this as a couple. And they weren't trying to do anything devious. Obviously, she outed herself on the audio, was trying to be respectful and not be on camera. But just know that, that seems to be, when you're in a room with a small table and 3 chairs, if there's somebody else there, unless it's the invisible man, But, in platform mediations, that is one of the things that you have to be considerate about.
You should be asking that before opening statement. Who are you? Why are you here? And then everybody else, who are the participants in the mediation, you say, is it okay if they're there? If they give it their consent, the party can be there. If the party is problematic and hurting your mediation, caucus them out. That's how you save the problem.
All right, let's turn to the very back page, because before we eat lunch, Dave has given me permission to be the commander of my own ship during my presentation. And you may have noticed that I was trying to get some pictures of Susan when she was presenting online. Our newsletter, it comes out about 3 times a year. For the last 2 years, I had been asked, where are all the great pictures? Well,
There,
what do you mean there?
that camera will give you all the great pictures.
Oh, okay, well, I was like, okay, all right, I was thinking to myself, yes, I see that camera. But I would like to take a picture on my own cell phone. You may have been in one before, so if you'll indulge me after I wrap up this last part. I do want to give you last page, starting with 2019-004. Actually, I'm going to skip down to the 2019-003. 2019-003, a mediator wrote in a very long case scenario about a small claims mediation and the questions she asked and whether or not they were appropriate. Look this case up online to know exactly what not to do. It was almost as if instead of writing to the Meac, that this mediator was self-reporting a grievance against herself. I didn't copy it and bring it to circulate, but if you want to know what not to do in a small claims mediation, this Meac question is a wonderful example. We rarely get in Meac questions where people tell us situations that they've done or encountered that are so obviously counter to the rules, but you've got about 2 pages of case facts that none of them are appropriate behavior. So I just want to point that out for something that you can read that would show you some improper things to do. Looking at the next one, 2019-002, this case revolved around, now this is interesting, and I'm sorry Dave's out of the room, but Dave's a Meac connoisseur, so he probably has read this. A director was going for, not a director, but a senior mediator who had some responsibilities. You know how Dick would always sit in the jury box and take statistics? A mediator of that role was looking over some past mediation agreements, found signed mediation from a year ago that had an interest rate that the mediator believed was illegal. So I don't know, let's say the party agreed to pay 30% interest, and there's a cap at interest on loans in the state. And again, I'm making these things up at 24%. I don't know that, but let's just say somebody knew it and it was accurate. She wanted to know if she could go back and tell the parties that they had entered into an illegal mediation agreement. The answer to that is no, you cannot do that. So I don't know in what shape or form you would ever be doing that, but just know that that would be an inappropriate behavior. So if Dave was looking through some agreements that you had written in the last 2 years and he finds in his mind a flaw, Dave would not be calling up the parties and telling them, hey, you really should have done better, and really you have an actionable item that you can move forward on.
Remember unconscionability. And I think that's a test. If you find that something is unconscionable, deal with it. Terminate the mediation. Don't let them do it if you can avoid it.
Right. And honestly, in this particular case scenario, I've seen those interest rates floated around. I don't know if it's usurious or not, and I'm not there to give legal advice. One of the parts about not having the type of education that Dave does in the law, I don't really know. I mean, if the parties want to agree to it.
Dave doesn't know either.
And there was an older Meac opinion that basically says that is legal advice.
Yes.
We're now giving legal advice when I'm telling them about interest rates.
Right. So I knew that Dave would know that opinion. And the last one that I wanted to talk to you about is actually back to the top, since I do have a minute. 2019-004, the person who inquired about this opinion attended our last in-person conference. And during one of the workshops, a family mediator responding to, I guess, a question and answer period, told the workshop group, imagine 100 people, that her practice is, she didn't use these words, shame a party, but basically demands that the children attend the mediation in divorce cases so that their parents behave properly.
Somebody,
I saw her
that
do
was,
that.
Okay.
that was him.
All right.
That's awful.
So that is, and when that opinion came in, this opinion doesn't, the summary doesn't go into these are children and this is a demand in a family case. But if you read the full opinion, there are even some citations to not necessarily family mediation, but dependency mediation and some other case law in family, because typically if children are participating in a court proceeding, it's because a rule requires it or the judge has given permission. For a mediator to insist that children attend the mediation is beyond her role and authority, let alone to say whether or not it's I don't know, if they're 17 and 18 and the parents want to involve them on, I don't know, residency or something, maybe that makes sense.
Except dependency. Dependency, child is a party.
Right. But whether they appear.
It's kind of up to you and the judge.
It's up to you and the judge, right? So, and that's some of the sites on this. So I doubt that you're going to make that a ground rule, but just know that there are some things about participation that are just not in your authority, let alone whether it's a good idea or not.
I love it when they bring their new girlfriend to mediation. Like divorce mediation.
Yes.
I love it. I literally saw two guys. I was on the 23rd floor of the courthouse in Dade County, and that happened. Somebody brought their boyfriend. And I looked out the window, and there are two guys duking it out on Flagler Street because of that mediation.
Really, because usually one of my mentors was the ADR director in the 9th Judicial Circuit for a while, and she said the worst was the women fighting in the waiting room. Like you're waiting to go to mediation, and it's in a large room, you're not in a small room, but most of the fights that she ever broke up were the women waiting out in the hallway.
And just remember, they're all crazy. Everybody who's litigating is crazy.
I thought you were women, I was like, hey.
I was about to ask that too. I was like, oh, well, in
That was we're about to have a Meac question.
Absolutely. So are you inclined to help me out with a photo?
Sure.
All right, so let me do what I normally do, and I learned this from Kate Marshman. I learned many things from Kate Marshman, but this is one of the things that I learned, and she told me it was from her days in I think she was in TV broadcasting as an undergraduate. So I think she wanted to. What, weather?
Yeah.
Yes, that's what I was about to say. I'm thinking she has weather broadcasting in her background. So staging was a thing that, you know, she had in her forte. So I'm gonna ask anyone who's 5'10" and older to come up and be our background. Taller. Taller. Yeah, that would be horrible if I called you by age group. Could you imagine? All right, so. And Dave, we can get you in the picture, right?
I can do that.
Okay,
You can get in, I'll take it.
Okay.
You're not older than 5'10".
Go ahead. We used to be over 5'10".
I'm gonna take this advice too, I like that. Oh, you have to bring people up, because inevitably you have
That light's gonna
the
be a
short-
problem.
shorter people trying to go,
Oh.
can we turn that off here?
Why don't you get behind me?
Is this still rolling?
They got a big number of 5'10".
Dave, I'm gonna pause this while y'all take lunch. Is that okay?
You don't wanna watch this eat.
Well, I don't.
Problematic unit.
Having
I'll
problems?
level with you. When I was here, we were doing 2,400 cases a year. 1,200 small claims, 1,200 of everything else. We're lucky if we did 200 cases last year, and the settlement rate was 32%. I'm not talking about you guys, I'm talking about the unit in general, and the settlement rate is 32%. So we got a problem. I think a lot of the problem is because we're not getting signatures. Because we can't get signatures, we're fixing that by, I think the fix to that problem is keep them on the phone while you're doing the agreement. And don't end the mediation until they sign the agreement. I think that'll be part of a fix. I think the other part of the fix is in 10 days, report no agreement, because you'd be real surprised how quick they start responding when you're doing that. And you can always do an amended report saying that they made an agreement after you reported no agreement. So there's no harm, no foul there. And I don't want to clog the court system with adjournments, because 60% of the calendar is adjourned cases waiting for signatures. And that's not fair to the court system, that's not fair to the parties, that's not fair to you. So we're gonna fix that by holding it up to 10 days, no longer at the end of 10 days if they haven't signed the agreement, report no agreement.
Dave, you're talking about small claims court now.
I'm talking about everybody.
See, you talking about that?
Because we're still gonna do telephonic. Now, what I'm looking for is a group of volunteers who are willing to do nothing but telephonics. Because in that way, I can institute Zoom instead of telephones, because we can get you Zoom permits, we can get you the licenses. And Zoom fixes a lot of the problems I had against telephonics, like reading body language and like making sure that nobody else is in the room. It's pretty close to being there. I'd rather have you in person. I'd rather have it in person. It's a lot easier. But on the other hand, we can reach out with people all over the state to resolve our disputes. So I can get mediators from everywhere. Basically have done that.
How are you gonna be discriminating? Which cases go to Zoom and which cases have to be appearance?
If it's a telephonic, if the court order is telephonic, I want to do it by Zoom.
In these rooms here? Like we've been doing telephonics?
I don't care if you stay home and do it.
You mean total telephonic or one party?
If one party's here and the other party is not, you can still do it by Zoom. It's the
So
other
in
party.
other words, you're gonna have computers in every one of these rooms here?
No, you're gonna be doing the Zoom by home.
Oh.
Okay, so
And if that doesn't work out, tell me, look, I am not stubborn. I want to hear from you. There is no such thing as a stupid question. The only stupid question is the one you don't ask. And then you screw up, you have to fix it and do it over again anyhow, so it takes 3 times the time to do it. So I want questions from you.
Okay, stupid question number 1.
Okay, you get 3 in a lifetime.
So if we come here on a Tuesday to do them, will we just be doing live ones? And how are you going to decide whether this one's gonna be sent to somebody at their house, or whether this one is gonna be sent to somebody in the room, or how, I don't understand how it's
Two
all.
parties are gonna be by phone, it's gonna be at your house. If one party shows up and the other party isn't here, I hate to do it by telephone, but I think I'm gonna let the parties decide how they wanna do it. If they wanna do it by Zoom, we'll figure out a way to do it, because I'll always have my computer with me. So I'll always have a way to do a Zoom telephone conference. As a matter of fact, I may get an extra computer down here.
Just go to Goodwill and buy about 4 little laptops and just stick them in arms.
I think it's probably more complicated than that.
It seems like 90% of our ones where we have one person here and one person away are simple debt things that get resolved very easily anyway.
Yeah, exactly. Yes, ma'am.
This is back to waiting on the agreements to be signed. When we come here in person, anytime we got an agreement, we wrote it up and it was taken to Veronica or Jennifer. They looked over the agreement,
I'm gonna
they
do that
signed
too.
off on it. Okay, so, and then I'm assuming staff would send it. But if we're at home doing these and you're telling us to send the agreements, no one is looking over the agreements.
If you're doing it from home, you're gonna be responsible to see that the agreement's in there. That's the only, the rest of you that are here, we'll take care of it. But if you're from home, you're gonna kinda have to be responsible to see that that agreement's signed or not signed.
They don't have access to CCS, so they can't check.
What is he saying? I'm sorry.
That's true. Well, look, you're gonna know immediately, because they're gonna sign it while you're still there, and it's gonna come in, and it's either signed or not signed. If it's not signed, then give them the 10 days. And I guess, under those circumstances, I guess staff will be responsible for checking the 10-day period. You just gotta alert us that there is a 10-day period. I mean, you all have to let us know what's going on in cases like that, so we can pay attention.
So
Yeah.
David, if I'm doing a telephonic with two parties, I type up an agreement. I type the agreement up. It takes 10, 15 minutes for an old guy.
Or you can check boxes. Because we have a form agreement.
Settlement agreement.
We have a form settlement agreement. You can check boxes if you don't wanna type the agreement.
I've never seen it.
Are we gonna go over
I've
that?
never seen it.
It's the same agreement we used for my
We've
tenure.
never seen that.
Let me just add that in Alachua County, that's exactly what they do. I mentioned I was observing the mediator on Zoom brings up the template settlement agreement. It's in Word, it's not in 3-part form. I don't even know if you got it. Larry probably remembers 3-part form, Sharon having to press hard through all of those copies and stuff. Yeah, I could never do that correctly, but, and then she's typing and the parties are like, no, you made a mistake. There's an extra 1 in the address or whatever. And then they use Sign Now as their platform. And unless somebody says, I can't do that, it's sent through Sign Now. The mediator's still on the phone with them or on Zoom, I'm sorry. And you hear them say, yes, I just got it. She's like, okay, sign it now while we're on, and it'll automatically route to, and I think it routes in their case to the mediation department, however it's routed. And then it was all done, just like they.
We will e-file it. The mediation department will e-file your agreement.
That's the same
Unless
thing we
you're-
already do.
Pardon me?
That's what we do.
Yeah, that's the agreement form. Pass it around, I didn't make enough copies. Wonder if I
start over here. But it's the same thing we already do, David, the way you said it.
Yeah, I thought it was some kind of just checkbox thing.
That's what we do every time.
Yeah, that's what we do.
That's the agreement. And there's another document that's a report. There's a third document that's an order. I wanted to keep the court's orders on the agreements. I want pure agreements.
Then if you're
The mediator does not have to sign the agreement, but can. It's up to you.
Do we have to put our name on it?
No,
No. Okay.
you have to put your name on the report. The report is our communication with the court, our only communication with the court.
Has the report changed in the last year?
No, that is not. I'm gonna use the same report. And I was telling you, I've made a couple of changes. I've asked the contract mediators to do a few things that they probably not have done before. The reason that I did that is For the 10 years I was here, we were number 22 in the state in size and number 4 and 5 in the state in numbers. Which means that we were one of the top producing units in the state. And we're almost at the last in size. I'm real proud of that, and that's where I want to be. And so I am using the same techniques that I used when I was a director before. My attitude is, if it ain't broke, don't fix it. And it wasn't broke when I left, and then they tried to fix it and broke it. So, you know, what can I tell you? Yes, sir.
Dave, I don't know if you're getting our feedback right now about this thing about getting signatures. If you want to, if you're gonna talk about it again later, I'll wait. If not, I'll tell you
No,
my
let's talk about
concern.
it now.
My concern about that, I don't mind the telephonics, but, and I'll tell you a story that happened to me. I didn't know we should put star 67 ahead of calling someone, and I was just using my personal, and I got back several calls that I was very uncomfortable with, and Veronica had to go handle that with the person. But the biggest problem I have with me running down those signatures is, once again, I'm using my personal stuff because they gotta send it back to me, but it's also the time for me.
You're talking about telephonics or Zoom or?
I did telephonics. And what I hear you saying now, you're gonna change the procedure that would ask us mediators, volunteer mediators for the small claims to get the signature from the person. And I'd rather come here, and that's probably what I do, but I'm just speaking up my concern about it.
I decided that you're not gonna know if they're signed because you can't get on CCIS.
Thank
So
you.
your responsibility is to get it signed during the mediation, and if you can't, then we'll do it. But you gotta report that to us, you gotta tell us there's a problem.
Well, you just said the same thing, you just said we are gonna have some responsibility for getting signatures? I'm sorry if I
When
misunderstood
you're
that.
doing a mediation, at
Yeah,
the end of the mediation, you're gonna produce an agreement and send it out with signature software. We're gonna give you signature software. They're gonna sign it, send it back to you.
Yeah, I know what
You're
you're
gonna
saying.
report agreement. That's option number one. Option number two, you do it, somebody signs it, somebody doesn't sign it, okay? You're gonna hold it for 3 or 4 days, and then you're gonna tell us. No, that's wrong. If you don't get it during the mediation, staff will be responsible to get it. Because you can't get on CCIS, so you don't know what's
If you
behind it.
do it during mediation, they still need to have the signed now account to fill in the fields.
You're gonna have to sign now. I've talked to Grant has license for a lot of sign now.
They need to training on how you do that.
That'll be one of our weekly trainings on how to get signatures.
How are we gonna, do, like, you know, I noticed Dick's not here.
Dick's coming back.
Oh, okay, because I was gonna say, how are we gonna do that without Dick here, you know?
We're
Because
gonna
he
do
was
that
kind of
with Dick here.
coordinating. Yeah. And so I was, you know, so, okay, so that won't change. All that's gonna be just like it was.
Everything is gonna be like it was.
Okay,
Pretty
cool.
much.
Cool.
Except for holding, you know, for the contract mediators. This is more aimed at the contract mediators than the volunteer mediators.
Okay.
You know, but the hardest thing to do in a case that you're not present personally is to get signatures. And I don't wanna hold it against you as an impasse if you have to report no agreement because somebody didn't sign a signature. So I wanna know that. I wanna know how many of those occur. I wanna know, so I can figure out a way to deal with it. And the way that you're gonna do that is if you're waiting for signatures and you don't get them, I will tell you at the end of 10 days and then you report no agreement. Or I will tell you that they agreed to it and then you will report agreed. Or I'll do the reports, maybe that's a better way to do it.
Yeah, see, David, you're saying the word maybe a lot.
Well, I'm trying look, this is the first time we have talked.
I understand.
I'm throwing ideas out to come to a solution.
Let's
so
make
you
sure
guys
they're
can have
ideas. make sure they're ideas and not policy.
You'll know when it's policy, I promise. Right now, we're having a brainstorming session and I'm thinking out
Okay,
loud.
that's good to know.
If you want signatures from mediators, and I hear a lot of your thoughts having to do with the contract and not the volunteers, which I'm glad it's not. You can get signatures from us ahead of time on those agreements that you're gonna have to handle, and then when you use it, we get just a copy, you send us a copy of it. Either way, that can help you with that.
Tell me that again.
You were concerned about getting signatures from the mediators as well.
Right.
And you talking about having to call them back after 4 days to tell them what to do, because you didn't hear back from the parties. To cut out the 4 days, I am suggesting you maybe, no, that you wouldn't do that.
If you don't have signatures at the time you turn in the mediation agreement and you haven't filed a report agreement, we will deal with the signature.
Okay, that's a policy.
That's a test. We're gonna try it out. You know, yeah.
This is totally different, it's shifting a little bit. I've noticed a couple of times today you used verbiage. I don't want you to have to eat and impasse.
Let's talk about that because it's important. Go ahead.
Yeah, so my point is, we spent a lot of time talking about self-determination today. Allowing the parties to decide if they're going to reach an agreement, so how does that relate to eat and impasse?
I had a situation. Okay, I care about settlement rates. I gotta tell you that, I care about settlement rates. I want a 75% settlement rate. And I'll tell you the exact example of how that came about. I was doing my first dependency training. I did it for free for everybody who attended, because everybody who attended was staff. Well, one of the staff members got fired before the training, and I already committed to train her. So she came to the training. She did everything she could to undermine, everything. Fortunately, I had my mentor and my good friend Perry Itkin taking the training. I hit the wall. I got to tell you, I hit the wall after 4 days. My brain just went mush, and Perry got up and did all this thing. It was a perfect transition. It was a cool training. Anyhow, the question she said, and she basically impassed most of her cases. Let's put it that way. I don't remember the settlement rate, but she didn't settle. And she said to him, Sharon Press, who was the DRC director at the time, says the outcome is more important. No, the process is more important than the outcome. I 100% agree with that. And then she said, so impasses doesn't matter. And then he says, well, if you impasse all your cases, you're not going to be much help to the court system, which makes sense to me, okay? So I am going to do everything that I can possibly do to help you get the settlement rate to where it needs to be. The first thing that we're going to do is this training.
Right.
This trip, because that was one of the major reasons that we were one of the best units. Were we one of the best units in the state, Kimberly?
Yes, you were.
Thank you, Kimberly. We were one of the best units in the state. Why? Because we trained all the time. And we talked about stuff like this.
Right.
And I want to hear your problems. I want to hear your problems because my job is to fix them. That's what I'm here for. I'm fix-it man. I'm handyman and fixing this unit. And by the time I leave, we pretty much will be back to where we are. Contract mediators, I'm about to start setting cases on 1,000 backlog cases.
Oh, wow.
So we're going to be busy for a while. But then we have 10 mediators to do it. So everybody's going to get plenty of cases, I promise, more than you want, probably. Again, number one, ethics. Always ethics. Number two's got to be settlement rate. I'm sorry. I shouldn't care about it, but I do. Because we're wasting our time if we have 30% settlement rate, we're not getting rid of any cases for the court. All we're doing is clogging them with the Germans. And that's one of the problems that I have seen. Again, I'm not going to change much. I'm gonna change what needs to be changed.
Dave, and I can appreciate what you're saying as far as your real goals, what you want us to be. And one of the things that I just personally want to suggest that you do, you know, it was rough. I'm sure it was rough for the staff, all this COVID stuff, but one of the impacts, it didn't feel good anymore being a volunteer.
Well, I hope that you will start feeling good
And,
again.
well, I'm putting it out there simply because I think it's so important, and that's what that call I made to you, for all of us, so that we want to help. We felt good. I knew we had great training here.
Sure.
We felt good about being mediators, and I think I can say that.
You did, you had to admit it.
You've got to build us back up again, because
Well,
we've
that's
lost
my-
something there, okay? That's all I can say from the staff to the administrator.
And that's why I'm here.
Okay.
You guys matter a lot. I want you to know that from the outset. You matter a lot. You saved the court system millions of dollars.
Right.
By mediating. And the judges love it. The judges love you guys. I mean, it's clear from their opening statements that they love you guys. I want to guide you to getting back to where we were. Now, there's going to be a lot of ways we're going to do that. One is have these training sessions where you get to talk and you get to say whatever you want to say, and I will listen to you, and we will talk about it if I don't understand you, and I will make changes accordingly. Again, this is a test, okay? I'm going to try it out because I recognize that one of the major problems that this unit has, that I've got to be statewide, is getting signatures. And impassing cases because they don't have signatures. And that's what I mean. I want to know why there's no signatures, why they impasse the case if it's just not a normal impasse. Because I don't want to hold that against you as an impasse where you did your job and somebody just changed their mind. And that's why I want to know. I don't want to know on the report, can't report it, but I want to know maybe by a little comment on a different paper that this was impasse because of signatures.
Dave, can I ask you a question?
You can ask me too.
It's kind of a fine point. I think you're right. I think the big problem is not getting settlements, it's not getting signatures. Because we're doing the same thing, but this thing about impasse does concern me. I really am opposed to trying to force an impasse. So I will not do it.
I don't want you to.
If it's an impasse, it's an impasse.
Well,
and when you keep saying, I'm not gonna hold that against you, I don't think anybody should hold it against me. If as a mediator, I'm not able to bring these parties together. It's their job, if they want to settle the case, I'm there to assist them.
I agree with you 100%. But I'm seeing statistics where you impasse 8 out of 10 cases. Not you particularly, but I'm seeing statistics where 8 out of 10 cases are being impassed. That's not helping anybody. And let me tell you quickly one way to avoid an impasse. Creativity is critical. You have to be able to point out options. If they can't go for one option, you keep doing options until they get it. And that's really, so don't give up on them after the first time when they say, oh, we can't settle this case. And my response to that is always, oh, you have little faith, you know? Because 90% of my cases settled, 88% of my cases, yeah.
Remember when Susan talked about the demeanor rule? And she said we could all remember it because it's one sentence. I don't know about you guys, but I have trouble remembering one sentence nowadays. Like, you hit that certain age point and I'm thinking, did I just dump half of what I knew before? But the very first word, there's 3 words used in that, is patience.
Right.
And in the last 2 years, I would tell you of the cases that I saw, that was key. That was key to the parties being able to resolve, not the signatures, which is an issue everywhere, but it was the mediator's patience in typing up the agreement while the parties are still online, letting the parties give feedback. Maybe the parties just the last one I observed, the parties had to go check to make sure that their platform they had an older laptop. They had to make sure that they wouldn't reject Adobe. I don't know what they did, but he said, I need to step away for a minute and bring down the camera. I don't even know if I have this, application or I can receive it. Or What's your email address? Oh gosh, I forgot. Hang on, Mr. Mediator. And the mediators were so patient while all this, the other side too, was all going on. And I don't want to suggest to any of you that you're not patient, but just, it seems like everybody's had a rough couple of years. And I have never, I probably would not have pre-COVID picked patience as the key to having parties be able to resolve their case, but I definitely see that in the last 2 years, being patient while they get through the technology, sign the agreements, and the mediators that I've largely seen online across the state are staying online with the mediators. Maybe not through full signature, but definitely on, yes, that sign now email came in. Yes, in the next hour, I'm committed to signing it and returning it. So that piece, like Dave said, has been creative. And I don't know that we did that on telephonics before. I certainly was in the category of mediator who would prefer not to do telephonics. Now I'll tell you the mediation, it was a little bit longer because all those steps had to take place. But at the end, the agreement signing was not the big issue because because of the procedures. So
I used to have 5 Ps for mediation. Professionalism, patience, perseverance, patience, and there was another one. I don't remember. Probably patience. Yeah.
I'm wondering if this 30% statistic that you're worried about was an administrative glitch, because I remember toward the later days of the telephonic mediation, I stopped doing telephonic mediations about 4 months ago. I just couldn't take it anymore. And at the time, we had a change in policy, and here I'm going to call on my colleagues to help me, that we were supposed to, even if we reached an agreement, when we sent it in, were we not supposed to put an adjournment on that as a check date while they waited to see whether they could get the signatures? And I'm wondering if it's not the case that those adjournment dates were never changed and they became impasse dates, or they got recorded statistically as impasse dates, because 30% is way too low for
I'm telling you the
did.
numbers that I saw. I didn't see any mediations. I got the numbers. I looked at the numbers were 32%.
I think it's worth following up on that.
No, and I'll tell you why. May 1st starts a new world.
Okay.
I don't care what
All
happened
right.
before May 1st. I care what happens after May 1st.
That's fine.
So I'm not holding anything against anybody. I'm just looking at numbers. I mean, I'm not here to judge you. I'm not here to do anything. I'm here to improve the performance of the unit. That means our performance. That means your performance. That means everybody's performance. And I want to tell you, if you've got problems with performance, come to me. Tell me you're struggling, and I'll help you. That's why I'm here. I mean, I've mediated, God, I don't know how many cases I've mediated, well over 2,000, I'm sure. And my settlement rate was frankly almost 90%. There's 2 cases I can't settle. I can't settle the case where one or both parties is irrational, and I can't settle a case where a lawyer stands in my way and wants to go to trial. I can't do anything about that. So, and the reason, and when I say eat an impasse, I took it personally when I impassed a case. I did, because I did everything in my power to avoid it. But I still took it personally. And it's not like leprosy, it's an impasse, no agreement. And it's going to happen. I just want to avoid it happening all the time, because it should. You should settle more cases than we don't. And that's you as a collective body. Yeah.
I'm interested in the role of the non-adjournment, the continuation.
Sure.
In the first 4 or 6 years I was working here, I don't believe I even understood there was a term like that. It just wasn't one of the things that came up. In the last 2 years before the pandemic, it became a significant percentage of the results of my cases. And I don't remember exactly why or what happened, but I just remember that that's true.
And let me tell you one of the problems with adjournment. They very often get lost in the cracks. And that's the biggest problem. And so let me tell you another problem. They're not productive. Because when you come back after an adjournment, if they come back, you're starting all over from scratch.
Yeah.
So they're really not productive. I mean, you adjourn a case, if somebody's drunk, I would adjourn the case. I wouldn't terminate it because drunk is fixable. If somebody's crazy, terminate it because it's not fixable. Really, I mean, it's that simple.
But the other party has to agree to that.
No, sir. Let me tell you something. You're gonna hear a lot of people say, it's your process. It's not their process. It's our process. We are the guardians of the process. How can it not be our process? And people have called me a directive mediator, and it's true. My attitude is, you stay away from my process, I'll stay away from your agreement, because that's the test. You have to be able to guard the process. You gotta own it, and you gotta control it. Sometimes the lawyers are gonna try and take it away from you. Don't let them do it, because you're gonna sit there watching traffic then without saying much. You should be guiding these people from the beginning of your presentation or your mediation. You should be guiding them to cooperate to get to that end settlement. Yeah.
There's a lot of moving parts to this conversation.
There is.
What I can't sort out is when you're talking about an adjournment. If I've got a mediation and one of the parties is an attorney and he is requesting or suggesting an adjournment. Saying I should.
No, adjourn.
Continue.
Look, in the presentation.
He needs to finish.
I thought I was finished.
No, what I'm saying is I'm going to allow that to go forward with the attorney suggesting the adjournment, correct?
Well,
Say one party.
I tell you what,
No,
can we hold
attorney.
this question? Because there is a rule that I'm gonna go over with you that tells you when you adjourn a case and when you terminate. And I think given that rule, we should be like, adjournments are when people are unable to participate anymore. Adjournments is for getting information. They don't have enough information to settle the case, so you adjourn it to get settlement. When you adjourn it, I want you to put the new date on it, because then we don't have to notice it. They're already noticed. So that saves a whole process and a ton of work. What time is it? Anybody?
Hey Dave, can I just add?
Absolutely.
Just judicially, not necessarily mediation, but judicially, right about last year, maybe not quite 12 months ago, every circuit was required to send the Chief Justice a case management plan because of the backload of cases. And it had set out very stringent deadlines for certain activities had to be accomplished. Luckily, and I looked at 80% of these, every case management plan that I saw had ADR, whether it was usually always mediation, but then it might have non-binding arbitration, it might have had parenting coordination, it might have had other things in the spectrum. But the ability for cases to be adjourned and come back another day may be limited by whatever your circuit's case plan is, or even Chief Justice determinations. And I can tell you at times of backlog, at other times in the courts, there are some circuits, and there are some doing it right now, that only allow one bite at the mediation apple. And if you're not done at that one bite, you're not getting back on the calendar. There's nothing saying that the parties can't negotiate among themselves and submit a settlement before the trial date or whatever the next court activity is. And in family cases, it might be something else, like a case management conference or hearing. But just know that if Dave comes back and tells you that this is the new world and how adjournments will be used, know that it might be larger than a Dave issue, larger than even just the chief judge, but that our Chief Justice Kennedy is being very aggressive about what he expects from the courts. And just know that not every court offers multiple chances at a small claims court-ordered agreement, and some don't allow it at all. So I just wanted to let you know that the culture at the very top of the judicial system, which was very, very, they would defer to the attorneys, defer to the chief judges. Now those individuals are under a tighter time frame from the chief. And if there are deviations in the case plan, they need to be resent back to the Supreme Court. I have never seen anything like this in my 25 years with the court. The court has, maybe in the mortgage foreclosure in 2008 or so, they did have some rules about what was going to be done in the mortgage foreclosure that were new and different, but not to say to the whole judicial system, you really need to tighten up. So even attorneys who are used to coming in, it seemed like attorneys came into court, honestly, to me, to just do the continuance stance.
Or to get the impasse.
Right, or so they'd be called up and it was like, I'd see 8 or 9 cases continued in a row, as long as both attorneys agreed, continuance. I don't know if that's what you'll see in court anymore, because the judges themselves are under timelines that are sometimes not at their discretion anymore.
And like trying to continue a dependency case is a waste of time, because you have to look for 15 people and get them back together at the same time, same places. It's never gonna happen unless it happens in court. Yeah. Well, sometimes one of the problems with dependency is they often sign it at the pretrial, at the not the arraignment, but the pretrial conference. In other words, in dependency cases, they set three hearings: mediation, pretrial conference, trial. And at that pretrial conference, often the agreement comes with everybody and they all sign it. So sometimes you don't know whether it's settled or not. Those cases, I guess you got to reject, because I can't think of any other way to do it. Okay.
Well, Dave, I'm sorry that I'm gonna have to leave as soon as your presentation starts, but we are crazy busy at the Dispute Resolution Center, so I need to depart.
Well, we thank you for your invaluable.
And I didn't want to give the impression that you didn't want to hear Dave's lecture, because it's always a pleasure to hear Dave training. So, and I do look forward to being back on a Tuesday. If you'll have me to observe, I would love to do that.
We will have you anytime you want. Yeah,
You're gonna find that a lot of the examples that the folks are giving you here today are really talking about Steve Black. And I think it would be helpful for all of us if you would have the conversation that Kimberly just told us about, this comes from the top, the inability now to get a second bite at the apple. If you would have a little one-on-one with Steve Black, that might go a long way.
And that's kind of my plan.
Yeah.
One day, Marcia and David came to court, and he had 15 cases, and they settled them, and the party agreed. And I said to myself, I am not going to let this go for 6 months getting the signature. So I grabbed Steve and I went over to his office and he signed off on it. So we got 3 agreements instantly on the day that's happening. If I have to do that with Steve, I will. I'm going to have a chat with him, telling him to ease up a little bit. And if he doesn't do it, then I'll go to the judges and make a complaint that that's going on, because,
He will, because years ago, we had the same situation. He was spoken to, and he drew back for a long time. So another stimulus from you would set him back again, I believe.
I think so too. And Steve and I have a good rapport, so I think I can solve that without too much problem. I'm going to try. If I got a problem, I'll deal with it then.